In this video, we shall discuss Indian judiciary, a very important topic for both prelims as well as mains of the civil services examination. This video you're about to watch is a recording extracted from my Unacademy Platinum course. My new Polity batch for CSE 2027-28 on Unacademy Platinum starts on the 15th of June. My first 3 lectures are available for all. All you need to do, fill the form provided in the video description, register and experience Unacademy Platinum for free. Now let's get started and discuss Indian judiciary.
Hello, good evening and welcome to Unacademy Platinum. Today, we have discussed legislature, an entity responsible for making laws. We've discussed executive, a body responsible for the implementation of the laws. And then there is the third organ, judiciary. And we will discuss judiciary in great detail, but strictly according to the requirements of the exam. Now, what is this judiciary? The traditional role of judiciary, which continues even today, is to impart justice. For example, when we discussed the idea of capital punishment, I told you the purpose, according to Sarmad Mehraj Sir, for any crime there should be a punishment, and the objective of the punishment is dual. 2 important objectives. One is to prevent the future occurrence of this crime. And second is to reform an individual. So which means you have to deter future commissions of the crime, and you have to also reform the offender. Punishment for crimes, ensuring law and order in the society, ensuring peace in the society. That's the job of the judiciary, which is to impart justice. But the job of judiciary becomes important when we are a federal polity. Why? Because in a federal polity where there are 2 units, one is the union and the other is the state, there may be disputes between the center and the state. And for that, we need a separate entity which can resolve these disputes between the center and the state. That is now the modern role of judiciary in modern democratic federal societies. Also, when it comes to doctrine of limited government, where we say the powers of the state are not unlimited. There is a limitation. There is a limit to the amount of powers that a state can hold, state can enjoy. And what if the state deviates from those limitations? What if the state decides to usurp the powers of others, decides to let go of these limitations imposed by the Constitution? For that, we need a judiciary which can keep the executive under check. The power of the judicial review, where the role of the judiciary is to validate the laws passed by the legislature, to review the actions of the executive. That is now the modern role of a judiciary. So the job of the judiciary in traditional time used to be just to impart justice, provide punishment to those who have committed crimes. But when the societies evolved, when modern democracies evolved, where constitutionalism evolved, we see the role of the judiciary is now slightly different. Apart from the traditional role, it plays the role of managing the disputes between the center and the states in a federal polity. Also, there are checks, there are limitations imposed on the state. What if the state violates those limitations? This is where the role of the judiciary comes. It will reimpose those limits exercise check on the executive and the legislature. And the most important power of the judiciary is judicial review, to review the acts of the parliament, of the legislature, to keep a check on the executive orders passed by the executive. When we look at India, we see in India there is a hierarchy, and we see an organically linked judiciary. What is this organically linked judiciary? There is a hierarchy that we follow. What is that hierarchy? At the top, we have the Supreme Court. Below the Supreme Court, we have high courts for every state. That does not mean that there can be one high court for one state. It may also be possible, and we know that there can be a joint high court for 2 or more states. That is why for 28 states and 8 union territories in India, how many high courts do we have? We have 25. But every state should have a high court. That does not mean one high court for one state. We can have joint high courts for many states as well. But we have Supreme Court at the top. We have high courts for every state. Then we have district courts in every district. And these are what we call constitutional courts. That means these entities are provided by the Constitution itself. But the year was 2008, 2009, when one more entity, one more layer got added. And that layer was Gram Nyayalas. These Gram Nyayalas, these are statutory courts. Now, what do we mean by statutory courts? Courts which are provided by not the Constitution, but by the law passed by the Parliament. And the law was passed called Gram Nyayalas Act of 2009, and statutory courts, Gram Nyayalas, were created. And the objective was that these Gram Nyayalas should be constructed, organized, established in every village. Whether that has happened or not, we will discuss. But the idea was Supreme Court for the entire country, High Court for every state, District Court for every district, constitutional courts, but then Gram Nyayalas, providing statutory courts to every village. Whether that is success or failure, we will discuss, but this is the hierarchy. And all these entities are organically linked. In a sense, if you're not satisfied with the verdict given by the district court, you can move the high court. And in some circumstances, even if you're not satisfied with the verdict given by the high court, you can approach the Supreme Court. So there is a hierarchy, and these courts are organically linked. And Supreme Court will supervise high courts. High courts will supervise district courts. And that's how organically linked our judiciary is. When we compare the structure with, let's say, United States of America, there what we see, we don't see hierarchy. We see every state has its own Supreme Court. And then there is a federal Supreme Court. What does that mean? Imagine a situation that you are in Karnataka and you have a dispute, whether it is related to land or property or whatever. This case will go to Karnataka High Court, and Karnataka High Court will give the verdict, and that will be the final judgment. You have no other option of moving to the Supreme Court, because for Karnataka, there is that Supreme Court, and that's the end of the story. That happens in United States. If there is a case in Chicago, if there is a case in any other state, Illinois, Florida, the case ends there. You can't go to any other court because that's the final court of appeal. But they also have a federal Supreme Court. which means it will resolve disputes that union government may have, the federal government may have with the states. It will look into those disputes which involve interpretation of the Constitution. So normally what happens in United States is that every state will have its Supreme Court. And all those cases, normal civil cases, criminal cases, they will end at the Supreme Court. The only type of cases which will reach the federal Supreme Court would be a federal dispute involving the federal government and the state government, or when the interpretation of the Constitution is to be taken into account. But that's not the case with India, because Indian Supreme Court can hear any kind of case, whether it is criminal case, whether it is civil case, whether it is a marital dispute, or whether it is a property dispute, whether it's a constitutional case, or whether it is a federal case, whether it is fundamental rights case, or any other matter. Any matter can reach the Supreme Court. Is that good, bad, or ugly? That's something that we will discuss in these classes. First, we will start with Supreme Court, and we will focus mostly on the Supreme Court. We will have a slight discussion on high courts as well. We'll have very minimal discussion on the district courts, and we will have some important pointers for the Gram Nyayalayas. But our entire focus will be on the Supreme Court. Why? Because as per the PYQs, as per the trends over the past 10, 11 years, mostly questions related to the Supreme Court are asked. Yes, there are other issues, other entities, for example, tribunals, for example, Lok Adalats, that we will discuss separately in the form of tribunals and other alternate dispute resolution mechanisms. First, we will look at the Supreme Court, then we will look at high courts, then we will look at district courts, then we will look at Gram Nyayalayas, then we will discuss tribunals, then we will discuss Lok Adalats, and judiciary chapter would be complete. Okay, let's first look at the Supreme Court. Constitution says that there shall be a Supreme Court of India. And the Supreme Court of India shall consist of the Chief Justice of India and not more than 7 judges. These 7 judges are what we call brother judges or puny judges. That means judges other than the Chief Justice of India. So what Constitution says? Establishment and constitution of the Supreme Court, because we are first discussing Supreme Court. Constitution says there shall be a Supreme Court of India for the entire country. And what will be the composition? It will consist of the Chief Justice of India and not more than 7 judges. But can we increase the number of judges? Can we? Yes, we can. Who can increase the number of judges in the Supreme Court? That power is available with the Parliament. And how will Parliament increase the number of puny judges to the Supreme Court? By enacting a law. Now listen to me carefully, very simple, but very carefully. If we have to change Article 124, Clause 1, if we have to amend it, modify it, change it, and we say there shall be a Supreme Court of India consisting of Chief Justice of India and not more than 33 judges. Because right now the status is we have the Chief Justice of India, Mr. Gawai, and 33 other judges. How can we change Article 124, Clause 1?
Sir, we don't want amendment of the constitution, sir. We can change this by a simple majority only, sir. Parliament can increase the number of judges.
Parliament can pass a constitutional amendment act as well. I am saying conceptually, if we have to change this, which means we have to modify, amend the constitution. An amendment of the constitution needs Article 368, which means it requires a special majority. But Constitution further says that dear Parliament, if you want to change this provision, that you can do when Parliament will pass an ordinary law. And this ordinary law can be passed by simple majority. Because when we discussed amendment to the Constitution, I told you that our constitutional amendment process is flexible rigidity. That means there are some provisions of the Constitution which can be changed, altered without using Article 368, without using special majority. Because Constitution itself says, change these provisions, and these changes shall not be deemed as amendment to the Constitution. One such provision is Article 124, Clause 1, which says there shall be a Supreme Court of India consisting of the Chief Justice of India and not more than 7 judges. Can we increase the number of judges? Yes, we can. Who can do that? Parliament. How? By enacting a law. Is it a constitutional amendment? No. It is an ordinary law passed by Parliament by simple majority, and you can increase the number of puisne judges. And has Parliament done that? Multiple times. And now the current status is we have a Chief Justice of India and not more than 33 other judges. Tomorrow it can be 50. Later it can be 100. But for that, you don't need constitutional amendment. You can do that by passing an ordinary law by simple majority. Is that clear? Very good. Let's look at something else. If Supreme Court consists of Chief Justice of India and not more than 7 judges, but who is qualified to be appointed as the judge of the Supreme Court? Qualifications mentioned are you should be a citizen of India. If you are a citizen of India and you have 5 years experience as the judge of one or more high courts, then you are qualified to be appointed as the judge of a Supreme Court. If not, you should be a citizen of India and you must have had 10 years of experience as an advocate in one or more high courts for 10 years. If not, then you should be the citizen of India, and in the eyes of the President of India, in the opinion of the President of India, you should be a distinguished jurist. Maybe the professor of a law at a university, maybe somebody who has never practiced in the high courts, who has never been the judge of a high court, but who knows the law, who has the knowledge of the law. In the opinion of the president, you are a distinguished jurist. You can be appointed as the judge of the Supreme Court. Here itself, we will discuss also the qualifications for someone to be appointed as a high court judge. What is the qualification for someone to be appointed as the high court judge? But sir, you said we will first discuss Supreme Court and then High Court. Appointment process is same. That is why we will discuss appointments of High Court and Supreme Court judges together. Okay. In order to be appointed as the judge of a High Court, you have to be the citizen of India. But apart from being the citizen of India, you must have held judicial office for 10 years. Sir, what is this judicial office? Maybe when we spoke of that we have a Supreme Court, we have a High Court, we have a District Court. Maybe you are a District Court judge for the last 10 years. Now you become qualified to be appointed as the judge of a High Court. So if you are a citizen of India and you have 10 years of experience as a judge of a district court, or you're holding that judicial office, if not, 10 years of experience as an advocate in one or more high courts, then you are qualified to be appointed as the High Court judge, which means if you notice clearly, as a distinguished jurist, that is not a qualification for a High Court judge. If you are, in the opinion of the president, a distinguished jurist, then you can be directly appointed as the judge of the Supreme Court. In order to be appointed as the judge of a High Court, you should be the citizen of India and you must be a judge of one or more district courts, or you must have held a judicial office for 10 years. If not, citizen of India, and you must have had 10 years of experience as an advocate in one or more high courts. There is no such concept as distinguished jurist when it comes to a high court judge. Clear? But now the issue is, how should these judges be appointed? And listen to me carefully. Original constitution, as it stood on 26th of January 1950, it said every judge of the Supreme Court as well as High Court will be appointed by whom? By the president. But whenever you are appointing a judge other than the Chief Justice of India, you have to consult the Chief Justice of India. Constitution further said, whenever the president will appoint the judge of a Supreme Court or High Court, the president will have to consult whom? Such of the judges of the Supreme Court and High Court as he may deem necessary. And when the president has to appoint a High Court judge, the governor of that state should also be consulted. This is something which was mentioned in the original constitution. To make it even simpler for you, Constitution said, if you have to appoint the Chief Justice of India, consult such of the judges of the Supreme Court and High Court as you may deem necessary. Which means the president could appoint me as the Chief Justice of India. And someone will ask the president, who did you consult? The president will say, I did not deem it necessary to consult anybody. Because Constitution says, while appointing the Chief Justice of India, the president shall consult such of the judges of the Supreme Court and High Court as he may deem necessary. I did not deem it necessary to consult anybody, and this person is the Chief Justice of India. But apart from Chief Justice of India, when you have to appoint the judge of a High Court or Supreme Court, this Chief Justice of India shall always be consulted. Apart from consulting such of the judges of the Supreme Court and High Court as he may deem necessary. Which means, if I am the president, I have to appoint a Chief Justice of India. I will consult such of the judges of the Supreme Court and High Court as I may deem necessary. But when I have to appoint someone else other than the Chief Justice of India, I will have to consult the Chief Justice of India. And apart from consulting Chief Justice of India, I have to consult such of the judges of the Supreme Court and High Court as I may deem necessary. But when I have to specifically appoint a High Court judge, the president will have to consult the governor of that state as well. This is something which is mentioned in the original constitution. And the original constitution said that you will be holding office till you attain the age of 65 years. That means retirement age of the Supreme Court judge is 65 years. And what is the retirement age for a High Court judge?
62.
2 years. This is what original constitution spoke of. But then what happened? Convention. Convention means unwritten rule. Something that is not mentioned anywhere, not mentioned in the constitution, not mentioned in the rules, but something that we follow. And what were we following? Appointing authority is the president. What president will do? President will appoint the senior most judge of the Supreme Court as the Chief Justice of India. Now, who is the senior most judge? Let's say my age is 55 and Raju's age is 60. By the way, my age is not 55, I'm much older, but just to make you understand. If my age is 55, Raju is 60, but I was appointed as the judge of the Supreme Court in 2020. Raju was appointed as the judge of the Supreme Court in 2022. That means later. Who is the senior most judge of the Supreme Court? Me. Although my age is less, I am younger to Raju. But in terms of experience at the Supreme Court, in terms of when I was appointed to the Supreme Court, I am senior most. And president would always follow this. as a convention, as an unwritten rule, as some sort of consensus that whenever we have to appoint a Chief Justice of India, this person will be the senior most judge of the Supreme Court. That means of all these 33 judges, we have to pick one as the Chief Justice of India. President will look at who is the senior most judge, and that senior most judge will be appointed as the Chief Justice of India. That was a convention, unwritten rule. And whenever other judges, that means other judges of the Supreme Court and High Court were to be appointed, this Chief Justice of India was always consulted. The word is shall always be consulted. This used to be the norm, and we used to follow this convention. And for at least the 2 decades after the commencement of the Constitution, this is something that we were following. Who is the senior most judge of the Supreme Court? You are now the Chief Justice of India. And I will always consult you when I have to appoint a judge to the Supreme Court or High Court. I will always consult you. But it is only consultation. Consultation means I'm consulting you. Am I going too fast? Should I slow down? You'll say, yes, sir, you are going very fast. I will go faster. Because whatever you tell me, that's not binding on me. I'll go even faster. But if it is concurrence, English word concurrence, I am asking you, am I going fast? Yes, sir, you are going fast. Slow down. I have to slow down because your advice is binding on me. It is concurrence. So when I'm consulting you, I am only seeking your opinion. That does not mean I will have to do whatever you tell me. But if it is concurrence, then I have to accept whatever advice is given by you. But Constitution explicitly mentions the word consultation and not concurrence. This was the practice that we were following continuously. And then came 1973. What happened in 1973? Keshavananda Bharati case. Keshavananda Bharati case was a shock for the Parliament. Shock in the sense, Supreme Court invented something called basic structure. Dear Parliament, you can amend the Constitution using Article 368, but don't you dare touch what is basic structure. And what is that basic structure that we will define? Justice Sikri was the Chief Justice of India when Keshavananda Bharati judgment was delivered. On the last date, on 24th of April 1973, that was the last date of Justice Sikri. After that, his term would be over because he would retire, he would complete 65 years. Now we had to appoint the Chief Justice of India. In terms of seniority, there was this individual, Mr. A.N. Ray, a judge of the Supreme Court. But in terms of seniority, he was at serial number 4. By convention, what were we following? That the senior most judge of the Supreme Court should have been appointed as the Chief Justice of India. But who appoints the Chief Justice of India? President. President does not have discretion on her own. She would ask the Prime Minister. Prime Minister recommended to the President, no, appoint A.N. Ray as the next Chief Justice of India. What these 3 judges did? They resigned. Because they thought this is an assault on the independence of the judiciary. Because now you can hand-pick and cherry-pick judges as well. And why are you picking Justice A.N. Ray? He was a fantastic judge, brilliant judge, stunning judge. But the only mistake was, maybe he was committed to the ideology of the ruling political party. This is where Indira Gandhi gave a slogan, we need committed judiciary. This judiciary should not be a hindrance when we are implementing socialism in India. So we need judges who are committed to the ideology of the ruling political party. So committed judges do not mean that judges should be committed to their job. Judges should be committed to the welfare of the public. No, committed judiciary means judges should be committed to the ideology of the ruling political party. And that is how this convention of appointing the senior most judge of the Supreme Court got broken, and Justice A.N. Ray superseded 3 other judges and was appointed as the Chief Justice of India. Maybe if someone would have asked the President, sir, why did you appoint Justice A.N. Ray? and not someone else, not the person who is at serial number 1, the president would have replied, I can appoint a judge as the Chief Justice of India after consultation with such of the judges of the Supreme Court and High Court as I may deem necessary. And I may not deem it necessary to consult anybody. Or even if I'm consulting these judges, whatever they tell me, that's not binding on me. So I am appointing A.N. Ray as the Chief Justice of India. And these 3 judges resigned in protest. Immediately what Justice A.N. Ray did, you're aware, he set up a bench to review Keshavananda Bharti judgment. Nani Palkiwala came back. After 2 days of argument, after thundering before the court, he asked a simple question. Who asked for review? Justice A.N. Ray was left embarrassed because nobody had filed a review petition, and that bench was dissolved. After that, there was emergency. And in 1976, which is considered to be a black spot on the performance of Indian judiciary, an infamous case was decided by the Supreme Court, by a 5-judge bench of the Supreme Court. And that is known as the habeas corpus case, or ADM Jabalpur versus Shivakant Shukla, 1976. The case was simple. Can habeas corpus be suspended during emergency? Can any law passed by the parliament during emergency snatch habeas corpus? 9 high courts, remember, 9 high courts said, no, you can't do that. Habeas corpus is one of the most important writs in our constitution, without which the entire constitution would be a nullity. Our entire fundamental rights chapter would be a worthless piece of paper. Habeas corpus is necessary. You can't suspend it even during emergency. 9 high courts said, no, you can't suspend habeas corpus. Matter went to the Supreme Court. This 5-judge bench of the Supreme Court, by the majority of 4:1, said habeas corpus stands suspended during emergency. Why? Because we follow procedure established by law. Whatever law is passed by the parliament, we have to agree with that. We can protect you against the arbitrary actions of the executive, but we can't protect you against the legislature. If the legislature, in its wisdom, has decided to pass this law to deprive and snatch habeas corpus, we can't help. And there was only one judge who dissented. That judge was Justice H.R. Khanna, whose nephew was the Chief Justice of India till recently, Justice Sanjeev Khanna. Justice H.R. Khanna protested, dissented, said, what are you doing to our constitution? Without habeas corpus, what will be the value of our constitution? And he was praised by the foreign media. He was praised by the press. And he was in line to become the next Chief Justice of India. Because what were we following? A convention. What was the convention? That a senior most judge of the Supreme Court should be appointed as the Chief Justice of India. And Justice H.R. Khanna was the senior most judge in line to become the next Chief Justice of India. He was overlooked by Indira Gandhi. Justice M.H. Beg was appointed as the Chief Justice of India, who was not a senior most judge. And what Justice Khanna did, what his 3 predecessors did before him, resigned in protest. Be that as it may, over a period of time, this conflict continued. After the retirement of Chief Justice of India Sikri, Justice A.N. Ray was appointed as the Chief Justice, superseding 3 judges. The 3 judges resigned. On the retirement of C.J.I. Ray, Justice Khanna should have been appointed as the Chief Justice of India. He was overlooked. Justice Beg is now the Chief Justice of India. Justice Khanna resigned in protest. Then came the first judge's case, S.P. Gupta versus Union of India, 1981. 2 things. Imagine the role of the judiciary. There are cases pending in a high court against a politician belonging to the ruling political party. Imagine, just imagine, there is a case involving a political leader of the ruling political party. This case is pending in the high court. And the high court judge who is hearing this case is honest. what you will do? You will transfer that High Court judge from that High Court to another High Court. And you will plant a judge, a committed judge, to that High Court. And that judge will give a favorable verdict in favor of that political leader. Is this justice? Or is this the tyranny? Is it a despotic rule? Question before the Supreme Court in SP Gupta case was, number one, can a High Court judge be transferred against her will? That's question number one. Question number two, is the word consultation that is mentioned in the Constitution same as concurrence? Because when the Constitution says that the judge of the Supreme Court and High Court shall be appointed by the President after consultation with the Chief Justice of India, is this consultation same as concurrence, or is it only consultation? And can a High Court judge be transferred against his own will? Or is the consent of the judge necessary before you can transfer that judge? Supreme Court had to answer these two questions, and Supreme Court said, can a judge of a High Court be transferred from one High Court to another, even against his will? The answer is yes. And is consultation same as concurrence? No. Consultation and concurrence, these are two English terms. Both have different meanings. But sir, I have a question. What? Don't you think Constituent Assembly would have deliberately used the word consultation but would have meant concurrence? Maybe they were not aware of this term concurrence, and that is why they mentioned consultation. But the logic is, Constituent Assembly was aware of concurrence as well. How? In Article 370, the word concurrence was used. Concurrence in the sense, Article 370, which provided some form of a special status to Jammu and Kashmir. This Article 370 had a self-destruct clause. That means it itself said that I can be killed, I can be removed, I can be abrogated. But for that, the procedure was also mentioned. The procedure was, who can remove Article 370? Or who can modify Article 370? Who can abrogate Article 370? President. How? By issuing a notification. President will issue a notification and Article 370 is gone. But the same Constitution said President cannot issue this notification unless and until Constituent Assembly gives its concurrence. Concurrence in the sense, if the Constituent Assembly of Jammu and Kashmir says, no, President, don't issue that order, President can't. If the Constituent Assembly of Jammu and Kashmir would have said, President, please issue an order and remove Article 370, the President had to remove. So necessary condition was concurrence of the Constituent Assembly, which means the point here is, it's not that the Constituent Assembly of India was unaware of this English term concurrence. They were aware that is how this term concurrence got added in Article 370, which means they deliberately mentioned the word consultation when it comes to the appointment of judges. So when consultation is different, concurrence is different, that means as a president, I only have to consult Chief Justice of India, but his words, his advice is not binding on me. And I can transfer a judge from one high court to another, even against her own will. And that's how this process continued. Then came the second judge's case, which was filed by Supreme Court Advocates on Records Association. And the lawyer of the Supreme Court's Advocates on Records Association was Pali S. Nariman. Pali S. Nariman was one of those advocates who assisted Nani Palkhiwala in the Keshavananda Bharati case. And Pali S. Nariman is thundering before the Supreme Court. And Supreme Court gives the verdict. What Supreme Court says? Supreme Court said, appointment of judges. Okay, sir. It is an integrative, participatory, consultative exercise. Why? Because we have to select best possible talent to hire judiciary. Higher judiciary means Supreme Court and High Courts. Supreme Court said, what is this appointment of judges? It's a process. But this process has to be integrative, consultative, participatory. We have to participate. Executive will participate, judiciary will participate. We'll have to consult each other. Why? Because we would know somebody who is good, you would know somebody who is good. Let's consult each other. Let's agree upon a name and let this name be sent to president for appointment. What's the harm? We have to select best possible talent to the judiciary. For that, let's consult each other. Let's integrate. Let's cooperate. And we have to recommend names to the president, which is best. Supreme Court was asked by the government, what exactly do you mean? Supreme Court said, listen to me carefully. You have to consult Chief Justice of India according to the Constitution. Yes, because the Constitution says the president shall consult Chief Justice of India. Very good. But what is the Constitution after all? What is it? Constitution is what we say it is. Means we are the final interpreters of the Constitution. But come to the point, what are you trying to say? Chief Justice of India is not an individual. So, Chief Justice of India is an institution. So, if you consult only Chief Justice of India, it will not be proper consultation. Because you are only consulting an individual who is the Chief Justice of India. It won't be proper consultation. Consultation, in order to be proper, means you have to consult. Consult what? Plurality of judges. Plurality of judges means more than one. Who is this more than one? This more than one means Chief Justice of India and two senior judges of the Supreme Court. Consult this body. That would be proper consultation. Because if you consult only the Chief Justice of India, you are consulting only an individual. That's not what Constitution meant. Constitution meant consult the institution of Chief Justice of India. And in order to consult Chief Justice of India, you have to consult plurality of judges. Why? Because this is an appointment process which is integrative, participatory, consultative exercise to select the best possible talent to the judiciary. Only one individual does not have all the wisdom. Consult plurality of judges, consult Chief Justice of India, two senior judges of the Supreme Court, and this is what led to the emergence of collegium system. This is what collegium is. The government attorney general was leaving. Supreme Court said, no, come here. Said, what? Any name that we recommend is binding on you. Binding in the sense, this term that you see in the Constitution called consultation, it's not consultation, it is concurrence. What do you mean, Supreme Court? It means you can't initiate the process of appointment now. We will initiate. Means previously you would identify, you were part of the executive, you would identify that there are these many vacancies in the Supreme Court. There are these many vacancies in the High Court, and you will initiate the process of filling these vacancies because you will initiate consultation with the Chief Justice of India. Now don't do that. We will start it. We will look at what is the vacancy in Supreme Court. We will consult the High Court Chief Justice as well, collegium there as well. High Court Chief Justice, 2 senior judges of the Supreme Court, and we will tell them, is there any vacancy? Now let's start consultation. And then this body, this collegium, at this Supreme Court level, will recommend names to the president, and these names are binding on the president. You have no other option. But sir, why? You are rewriting the constitution. No, we are not. We are just interpreting the constitution. And who is the final interpreter of the constitution? Supreme Court. This led to the emergence of collegium system of judicial appointments. Few years later, the government, through the President of India, is sending an advisory to the Supreme Court. Just like if you read today's newspaper, the Supreme Court has decided that first we will hear states on the presidential reference filed by the President of India regarding the Tamil Nadu case, where the Supreme Court imposed timeline limit within which you will have to decide on the bills passed by the state legislature. That's presidential reference. When this judgment was given in 1993, immediately after that, the president sent this matter to the Supreme Court. My lord, please have a clarity. Please advise us, give an opinion. How do we appoint judges to the Supreme Court and High Court? Justice Verma was the Chief Justice of India. The same Justice Verma who was the head of the Verma Committee on Reforms after the gang rape of Nirbhaya. And it was Justice Verma who recommended the changes to the Criminal Law Amendment Act. But be that as it may, now 9 judges of the Supreme Court have to give this reference, this opinion to the Supreme Court. Have to give this reference to the government, because the government, through president, is asking the Supreme Court, give us your opinion. How do we appoint judges? Supreme Court said, don't worry, we will tell you. Number 1, if you have to appoint the Chief Justice of India, yes, sir. Outgoing Chief Justice of India will nominate his successor. And this successor should be fit to hold the office. What you did in 1973 superseded 3 judges appointed A and Ray. What you did in 1976 superseded other judges and appointed Justice Beg. Now you can't do that. Because now when the Chief Justice of India, his term would be about to get over, he will nominate his successor who is fit to hold the office. And who is the successor? Senior most judge of the Supreme Court. Which means when Justice Deepak Misra's term was about to get over, he nominated his successor, Justice Ranjan Gogoi, as the next Chief Justice of India. Why? Because Justice Gogoi was the senior most judge of the Supreme Court. Before his term got over, he nominated his successor, Justice Ramana. Before his term got over, he nominated his successor, Justice Yuju Lalit. Before his term got over, he nominated his successor, Justice Bobde. Before his term got over, he nominated his successor, Justice Chandrachud. Before his term got over, he nominated his successor, Justice Sanjeev Khanna. Before Sanjeev Khanna's term got over, he nominated his successor, Justice Gawai. That means now executive has no role in appointing the Chief Justice of India. Only the formal order will be issued by the President. The President is pleased to appoint Justice Gawai as the next Chief Justice of India. He is pleased at the face of it, but deeply he is hurt because he does not have any role. Because now the outgoing Chief Justice will nominate his successor. And who is that successor? Who is the senior most judge of the Supreme Court. But the problem is, this phrase, fit to hold the office, who will decide whether this senior most judge of the Supreme Court is fit to hold the office or not? Is it the outgoing Chief Justice deciding? Or is it the President deciding? We don't have the clarity. But going by what the crux of the Supreme Court judgment is, it will be the outgoing Chief Justice who will look at his senior most judge of the Supreme Court and then see whether he is fit to hold the office or not, and then recommend his name. If he considers that he is not fit, he will recommend someone else. But outgoing Chief Justice will nominate his successor as the Chief Justice of India. The President will only have to issue a formal order of appointment. Nothing more, nothing less. The Attorney General decides to leave. Supreme Court says, where are you going? We are not done yet. Stay, come here. We have a long thing to discuss. Okay, sir. This was about Chief Justice of India. Now, did you agree? Yes, sir. Now, if you have to appoint a Supreme Court judge, okay, sir, do you know what you have to do? You have to consult Chief Justice of India and 4 senior judges of the Supreme Court. Okay, sir. But previously you said Chief Justice of India and 2 senior judges of the Supreme Court. Now we are changing it. If you have to appoint a Supreme Court judge, you consult Chief Justice of India and 4 senior judges of the Supreme Court. Okay, sir. But sir, you said last time consultation is concurrence. Yes, that's what I'm coming to. Let's say this person A, collegium decides whether this person A, his name should be sent to President for appointment or not. Because how this collegium will decide? Supreme Court says any name not acceptable to Chief Justice of India can be sent to the President. Which means in this collegium, if 4 senior judges of the Supreme Court, they had to decide on this name, Sarmad, they all love me. You're very good. You can be a good Supreme Court judge. We are recommending you to the President. Appoint this person. But Chief Justice of India says, no, it should be my Bhatija. It should be my Banja, not this person. My name cannot be sent to the President for appointment because Chief Justice of India enjoys virtual veto in judicial appointments. Any name not acceptable to Chief Justice of India cannot be sent to President for appointment. Apart from that, if 2 or more judges do not agree upon a name, this name cannot be sent to President for appointment. Which means what? Chief Justice of India and others, they're also in favor of A. Yes, Sarmad, you can be appointed as the judge of the Supreme Court. But 2 other judges, they say no. That means 3 are in my favor. 2 are saying no. My name cannot be sent to appointment, which means as much as possible, this should be a unanimous decision of the collegium. Or even if one person says no, that much we can understand. That much dissent is allowed. But more than one, no. If more than one do not agree upon this name cannot be sent to President for appointment. And if Chief Justice of India says no, then in no circumstance can my name be sent to President for appointment. This is how you will appoint the Supreme Court judge. I said, sir, I have one question. What? Sir, let's say collegium recommends A to the President. Can President reject this name? Saying, no, we will not appoint this person. Said, no, don't you dare do that. Don't reject anybody. Whatever name we said, it's binding on you. Appoint that person. Okay, sir. Sir, if not a reject, can we ask you to reconsider? President, which means the union government, will ask the collegium, please reconsider this name, not Sarmad. Someone else, not him. Okay, we can reconsider but you give your objections in written. You can't reject a name, but you can ask us to reconsider a name. But whatever your objections are should be in written, not oral, not hearsay, not rumor. It should be written. But if we again say, no, appoint this individual, you have no other option but to appoint this individual. That's how you will have to appoint the Supreme Court judge, which means when you have to appoint the Chief Justice of India, outgoing Chief Justice of India will nominate his successor, who is the senior most judge of the Supreme Court, fit to hold the office. So Chief Justice is now done. We know how he or she would be appointed. What about the judge of a Supreme Court? The President will have to consult Chief Justice of India, 4 senior judges of the Supreme Court. They will decide upon a name. They will recommend names to the President. Can the President reject those names? No. Can the President request reconsideration of that name? Yes. But if the same name is reiterated again, recommended again, the President has no other option but to accept and appoint this individual. Attorney General said, okay, sir, I'll take your leave. Bye-bye. We got to know what we had to say. Where are you going? Come in, sit. We are not done yet. If you have to appoint a High Court judge, okay, sir. For that, consult Chief Justice of India plus 2 senior judges of the Supreme Court. Sir, this is so confusing. For one judge, 4 judges. For other judge, 2 judges. Accept it. Okay, so we have to appoint a High Court judge. We have to consult Chief Justice of India and 2 senior judges of the Supreme Court. Yes, sir. Would there be any role of the High Court? See, normally what happens, if in Madras High Court there is a vacancy, Madras High Court's Chief Justice, 2 senior judges of the Madras High Court, they will recommend names to the Central Collegium, which is the Chief Justice of India's Collegium. And then Chief Justice of India will consult 2 senior judges. They will recommend names to the President. And President is bound to appoint that judge as the judge of the High Court. Okay, sir. Sir, now can I go? There, sit. If you have to transfer a judge from one High Court to another High Court, sir, for that also we have to consult you? Yes. We can't let you do what you did in 1980s. Okay, sir. For that, what we have to do? Consult Chief Justice of India plus 4 senior judges of the Supreme Court plus 2 Chief Justices of the High Court. Which 2 Chief Justices of a High Court? Sending state and receiving state. If you have to transfer a judge from Calcutta High Court to Madras High Court, consult Chief Justice of India, 4 senior judges of the Supreme Court, and consult the Chief Justice of Calcutta and Madras High Court, which basically means you don't have to consult anybody. We will decide whether a judge of a High Court should be transferred from one High Court to another. You are only a postmaster. You will only issue an order. Nothing more, nothing less. Okay, sir. This is how it is. Which means India becomes the only country in the world where the judges are now appointed by themselves. Although the formal issuance of the order is done by the President is pleased to appoint ABC as the judge, XYZ as the judge, but it is done on the recommendations of the Collegium. All these appointment powers have been snatched from the executive. Matter continued. Those who are in favor of collegium system, let's discuss. And those who want reforms, let's discuss.
So I would say that collegium system needs a reform because judges are appointing themselves and there will be favorability as well. So interference by executive is somewhere required.
Interference by executive is required? Then what will happen
Yeah.
to the independence of judiciary?
Independence of judiciary is okay. That is required. Maybe we can do that. Maximum number will of judiciary, or judiciary will have, for example, 5 members of judiciary and 4 members of executive. That we can do, but a little interference with executive required, or else this will be only favorability basis.
Interference is a negative word. You can say consultation with executive.
Okay. Consultation with the executive is required.
Okay.
Sir, the number of cases pending for judiciary is much high, sir. To resolve those all the cases, the number of judges should be more. So, with the current
That has nothing to do with collegium. That's the job of the parliament. Parliament can increase the number of judges. Who stops them from increasing the number of judges from 33 to 3033? Or giving more judges to high courts? Or appointing more district judges? The real problem is at the district level. That's where the crores of cases are pending. Who stops the government from appointing more judges at the district level?
Sir,
I also
collegium
think
is
there should be some formations and some executive into the judiciary because considering the recent Yashwant Verma's case, and there's this phrase that nepotism also goes into the SC judges because uh, moreover, I have friends who are into judiciary. They say everyone who is a generational lawyer whose connections to SC judges is there, only they will be appointed as the SC judges. So there should
Only
be some
they, or
involved.
they also are appointed? See,
Only they.
nepotism, no, that's not the case. Okay, that's a fair point, but nepotism is everywhere. But nepotism also is not bad. For example, if I want my son to become a teacher, an educator, if he's good, you will accept him. If Mahesh Bhatt's daughter wants to become an actor, if she is good, she will be accepted.
What about Arjun Kapoor then?
If he gets a good film, audience loves it, he will get more films. If the audience does not love, that's why he's not getting any films anymore.
Should we bargain with such a pillar of the judiciary that nepotism, if the word if he's good should be accepted, should we bargain with such power?
So can you call Justice Sanjeev Khanna a product of nepotism because his uncle was the Chief Justice of India? He was the fantastic Chief Justice. Or Justice Chandrachud, whose father was also the Chief Justice of India. He may have erred here and there, but you can't doubt his capability.
But doesn't this closes the opportunities of maybe other people who can be tremendous judges, who can have a way higher
Justice
potential
Gawai
than
is the first generation judge. So are many others.
no.
Apart from third generation, fourth generation lawyers, does the system have a place for a first generation lawyer to also become a judge? Yes.
But when this point comes that only the CJI will decide his ongoing successor, will there not be any partiality when this things comes up?
Partiality would be if he will choose somebody from the audience. He has to choose somebody who is already part of the Supreme Court. Where will the partiality lie? Partiality would be if the executive would have the power to cherry pick. No, Inky Pinky Ponky, who is in my favor, you are the next Chief Justice.
Right.
I am
That
just
is-
playing devil's advocate. That does not mean that these are my views, my thoughts.
So,
You never come to know what my thoughts are. Yes, Isha.
So maybe a more democratic process, like among the judges, or maybe
Democratic
include.
process. Let's elect judges.
No,
Something which happens in United States. They also elect
I'm
judges at the
not
lower
aware
level.
of that, sir. Yeah,
Yes,
maybe.
they do elect judges.
Yeah, maybe among judges where the same, like a secret ballot sort of a situation. So there isn't a favoritism as such, and I don't know.
Even then, the list would be sons, daughters, son-in-laws, brother-in-laws, sister-in-laws, and we have to pick from there.
At least then we can't criticize them on how they chose people. So
But but your logic is flawed because you're still giving power to the judges to appoint.
Yes, so that's okay. It does give them a sort of independence, I think.
Okay. Yes, Indra.
Yes, sir. So, argument in favor, there is no political influence in collegium system. And there's expertise and experience of the judges. When we're talking about arguments against, there's lack of transparency, sir, like favoritism and nepotism as spoken.
Okay.
Also, it's like encroaching upon the executive's role.
Okay. Okay.
Sir,
Very
there
good.
should,
Yes.
sir, the appointment of judges, we can, the reform we needed, the judges which we are appointing, uh, as the collegium system, it tends towards more opaqueness. So there should be a transparency in appointment of the judges. And if we see that executive is coming in between the appointment and the judiciary, so it leads to the violation of our Article 50, that is separation of power. So in that condition, what we can do, we can set up an independent committee or a commission where people from based on ethical conduct, then legal experts, civil society, these member can independent judicial appointment commission can be set up, and they can select the judges to
Okay.
maintain transparency in judicial
Okay.
system.
Great. The first thing, let's look at the arguments in favor of the collegium system. When Justice Verma was later on asked, because he presided over that bench which gave the opinion to the President of India, he said, there are so many vacancies, and these vacancies are left unfilled by the executive. And maybe they're doing it deliberately, because when you have less number of judges, which means the pendency of the cases will increase, which means the cases against the politicians will also take a lot of time to resolve. Maybe that is why there is a conflict of interest. They don't want judiciary to perform effectively. That is why they try to scuttle judiciary. Since the vacancies are on the rise, now we are saying we will not depend upon the executive in filling these vacancies. We will initiate the process on our own. And we know, because we have been interacting with these advocates, they come to us, they go to the High Court. When judges hear the arguments of these advocates, they know which one to select as the next judge. How would a politician know? How would the executive know? Because we are in the middle of working with these advocates on a regular basis. So we have the best knowledge of selecting best possible talent to the judiciary. That was the logic. Second judge's case did not violate the constitution. How? Now we are saying, because of the collegium system, any name which is recommended by the collegium is binding on the president. Right or wrong? Previously also that would happen. Previously also. Before collegium system, the executive, the president will consult Chief Justice of India, and then they agree upon a name, and that name was appointed as a judge. Same thing is there right now as well with the collegium system. What's the difference? There's no difference. There is no difference at all. Supreme Court collegium, now instead of one Chief Justice, we have a group, which means it's more representative. It is easy to bribe one individual, but may not be easy to bribe all the 5 members of the collegium. Now it is more inclusive, more democratic by that logic. So this collegium will consult the Chief Justice of India, will consult the President of India. Whatever the name they agree upon, that name will be appointed. It is only when there is a stalemate. It is only when the President and the collegium do not agree upon a name. Only in that instance we say judiciary should have primacy. That's the only thing which collegium said. That's the only thing which second judges and third judges case said. Otherwise, we are following the same system. Previously, or if you are saying that there was no consultation prior to 1993, then it's a separate matter altogether. But if you agree that we used to consult Chief Justice of India, right now also you are consulting. Whatever name is not acceptable to President will ask, please reconsider. And we will also see what is the merit in your argument. We will reconsider. It's only when there is a stalemate. Because there was this uniform practice that Chief Justice of India, his advice was always accepted by the President. And if we have separation of powers cannot mean that executive will have the final say in judicial appointments. Separation of powers means executive will have its own sphere. Judiciary will have its own sphere. Legislature will have its own sphere. If executive has the last word in appointment, then it is not separation of powers. It is executive snatching the judicial powers. Now, when we say primacy of judges in judicial appointments, it is necessary for independence of judiciary. Because if this is snatched, then we will see committed judges being appointed to the Supreme Court, committed judges being appointed to the high courts. That would violate judicial independence. And this judicial independence is part of the basic structure of the Constitution. That is why the initial voice, that means who will initiate the process of filling the vacancy? Judges. Who will have the final voice, final word in case there's a stalemate? Judiciary. That is integral to basic structure. Otherwise, we will see a committed judiciary. But then something else. Justice J.S. Sarma said, collegium system would lead to a reduction in judicial vacancies. Because executive was hesitant in filling the vacancies. Now we will initiate the process of filling the vacancies, and you will see that we will fill the vacancies very quickly. There won't be any backlog. Just wait and watch. Mr. Vajpayee was the Prime Minister, and during his time, there was a talk after this third judge's case that we will have a body. Somebody was recommending that we should have a body. We should have members from executive, from maybe judiciary, from civil society. Let's come together and let this body decide who should be the judge, who can be appointed as the Chief Justice of India. But there was no political consensus, so this idea was dropped. Dr. Manmohan Singh also toyed with this idea, but couldn't materialize. In 2014, when Mr. Modi came to power, and perhaps one of the few initial decisions that the Modi government took was set up NJAC. What is NJAC? National Judicial Appointments Commission. And this was done through 99th Amendment. Now, Rahul, this 99th Amendment, what type of majority is required to pass this constitutional amendment?
Sir, it's an ordinary law. Why? Because appointment of judges is
I am
can be
mentioning here 99th
Constitutional Amendment.
Constitutional Amendment Act.
Constitutional Amendment Act, special majority we need.
Which flavor?
Flavor one.
Flavor
360.
Next is 2. Then 3.
Sir,
Then 4. Which flavor? Ritvik, which flavor?
Sir, it should be 2/3 of the members present in voting and
Flavor 3.
Who said flavor 3? Nirmal, which flavor?
Sir, it needs ratification by states also.
Yes. Why? Because it's a federal feature. Make any change to the structure of the High Court and the Supreme Court, it's a federal feature that needs ratification by not less than half of the states. So the point here is a constitutional amendment passed by both houses of the parliament and ratified by almost all the states in India. Through that constitutional amendment, where we had the popular mandate, imagine every single Indian wants it. through their representatives in parliament and state legislatures, they created NJAC, National Judicial Appointments Commission. And this NJAC said it will be headed by Chief Justice of India. It will have 2 senior judges of the Supreme Court. It will have a law minister, that means union law minister. And it will have 2 eminent persons. And at least 1 eminent person should be a woman. But who will select these eminent persons? Constitution said, for that we need a committee. Committee of Prime Minister, Chief Justice of India, leader of the opposition in Lok Sabha. Together they will nominate 2 eminent persons. And now civil society, executive, judiciary will be represented together in NJAC to appoint judges, to recommend names to the president for appointment of judges. Is this a good structure? Those who advocate in favor of the collegium system, they say, how can we entrust and share this responsibility of appointing judges with executive? We can't. Law minister's presence is undemocratic, unconstitutional, because we can't share anything with him. He's part of the executive. There is conflict of interest when executive will have a final say or an important say in judicial appointments, because let's not forget, who is the biggest litigant in India? The executive, the union government, against whom the highest number of cases are filed, and which files the highest number of cases. And to have the nominee of the same government having an important say in judicial appointment, that is conflict of interest. So we don't want this union minister. And has civil society matured so much in India, evolved so much in India, that we can select unbiased members from the civil society and make them part of NJAC? No. Because in India, the organic development of civil society has not sufficiently evolved. That means the citizens, you and me, we can expect only from judiciary. That judiciary, please insulate yourselves. Stay independent from other organs of the government, because we can trust you. It is in your hands that we place our liberty. And we don't want you to compromise or share your powers with the executive. And civil society we can't trust, because there is no maturing of civil society as we have seen in the United States. In India, civil society is still in its infant stage, nascent stage. That's how you can defend collegium system. Otherwise, we will see the repeat of what happened in the 1970s. But then there are those who criticize collegium system. Justice Verma said, we will be in a position to better fill the vacancies if the process is in our hands. Now, my lord, the process in your hands. And even then, 45% of the vacancies arise in high courts. 45% of the posts of the judges are lying vacant. And for God's sake, please tell me, how do you decide these names? Former Chief Justice of India, Justice Chandrachud, he is saying sunlight is the best disinfectant. Best disinfectant means there should be more transparency. Bring in more sunlight, open the windows, let everybody see what you're doing. How do these members of the collegium, what do they decide? What do they choose? How do they choose? What do they look into? On what grounds do they recommend names to the president? We don't know. Yet they recommend to everybody. Executive should be transparent. Right to information should be valued. Whatever you decide, whatever and however you decide, let people know. Transparency, transparency, transparency. But your own entity is opaque. We don't know what you decide. On what basis do you decide? Do you decide this on the basis of the fact that this person you are recommending is the son, daughter, or a family member of your own judges or your advocates? You know. Nepotism may be a reality. Is there a bribe? What is the conflict of interest? Is there a quid pro quo? We don't know. The entire process lacks transparency, lacks accountability as well. Shouldn't collegium system take the accountability of recommending Justice Verma as the judge of the High Court? Shouldn't they? Today, a judge at the district level, she's resigned. Why? Because the judge she accused of sexual harassment is now a High Court judge. How? And at the same time, when the judges are hearing a case whether politicians who are accused of crimes, whether they should be allowed to contest elections or not. Accused. Here is a judge who's accused of sexual harassment and now becomes the High Court judge. And where is it mentioned in the Constitution that the President shall appoint the judges of the Supreme Court and High Court on the recommendations of the Collegium? Don't you think you're violating the Constitution? That's the criticism. But perhaps the stinging criticism of the Collegium system was delivered by two judges of the Supreme Court themselves in a petition filed by an NGO, Suraj India Trust, way back in 2010. In this, two judges of the Supreme Court are now asking questions to the Chief Justice of India. When was this question paper set up? In 2010. We are in 2025. These questions have not been answered. Question number one. Dear Chief Justice of India, please tell us, don't you think that the judgments that you gave in the second judges and third judges case, it amounts to amending Article 124, Clause 2 of the Constitution? Because 124, Clause 2 said, every judge of the Supreme Court shall be appointed by the President after consultation with such of the judges of the Supreme Court and High Court as he may deem necessary. But you are saying now the President will appoint the judges on the recommendations of the Collegium. Have you not amended Article 124? Please answer, Chief Justice of India. Is there any Collegium system mentioned in the Constitution? Answer, dear Supreme Court Chief Justice. Can the Constitution be amended only by Article 368 or by a judicial verdict? In any constitutional scheme, can judges be appointed by judges themselves? By judiciary alone? Please answer. Please answer. Is the term consultation mentioned in Article 224 concurrence? But sir, it is 124. 224 is for the appointment of a High Court judge. There also consultation was required. Is the word consultation meaning concurrence? Please tell us. Please answer. For God's sake, answer. Can you make, dear Supreme Court Chief Justice, some of the lines, some of the words mentioned in the Constitution redundant? Redundant in the sense, Constitution says, while appointing the judge of a High Court, the governor of that High Court should be consulted. Governor. Where is the goddamn role of a governor now in Collegium system? And something else. Constitution said the President shall appoint judges after consultation with such of the judges of the Supreme Court and High Court as he may deem necessary. Such can also mean junior judges. But Collegium is saying junior judges, forget about it. Senior judges, 4 senior judges of the Supreme Court, 2 senior judges of the Supreme Court. Why not junior judges? Is there any convention that President is bound by the advice of the Chief Justice of India? We have seen Article 74, which says there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall act on that advice. Is there any such provision that there shall be an advice of the Chief Justice of India which is binding on the President? And is there a virtual veto for the Chief Justice? You are now becoming the judge, jury, and the executioner. Do you have a virtual veto? And shouldn't or should a larger bench be set up to overturn the judgments of the 2 judges and 3 judges case? Maybe set up a wider bench, 13 judges, to decide whether we want to go back to the system that we had in the past. These questions were asked in 2010. 2025, these questions are unanswered. But maybe in one way, judiciary has answered. Do you know how? Suraj India Trust is banned from filing any public interest litigation. Banned. You can't. And to be fair to the Supreme Court, it is not because of this case. Maybe this case has an impact, but because Suraj India Trust was filing various PILs, multiple PILs, regular basis, and the Supreme Court thought you are misusing and wasting our time, that is why from now onwards you cannot file any public interest litigation. But this is the scathing criticism of the collegium system. Then is this system better? NJAC, which will have Chief Justice of India, 2 senior judges of the Supreme Court, Law and Justice Minister at the union level, 2 eminent persons who will be selected by a committee. Let's discuss. Those who are in favor of NJAC, tell me why. Those who are against it, tell me why.
Sir, Jack actually gives the primacy to executive because of the 2 eminent person will be appointed by 2:1, like 2% coming from executive and 1 from
So
judiciary.
just to make it clear for others, whenever they will take a decision, it has to be a unanimous decision. But if there is no unanimity, then there is voting. And if 2 or more members don't agree upon a name, that name cannot be sent to president for appointment, because even with NJAC, who could have appointed judges president? But instead of consulting collegium, instead of consulting such of the judges of the Supreme Court and High Court as he may deem necessary, the president would have to consult NJAC. But when NJAC will meet, any name which is not acceptable to 2 or more members of the NJAC cannot be sent to president for appointment. Now over to you.
Yes, sir. Apart from that, there are like the veto which earlier was with CJI, it now shifts to executive. So it is not like one extreme.
CJI did not have the veto in the original constitution. That power was arrogated by the Chief Justice to himself.
But we are trying
What
to
was not there in the original constitution.
Yeah.
How can you claim that we give it back to me?
No, I am saying that we are just going to another extreme of extreme. If CJI veto was there, it should not have been, because via media is the path we should be adopting. But rather we chose the other extreme of having the primacy of executive. But the real solution lies in between consultation of both faction, as done in most of the polities all over the world.
Then you are in favor of NJAC?
No, sir, actually,
Because previously there was executive primacy. With collegium, there is judicial primacy. Now you want something as a via. That is NJAC.
Yeah, but what NJAC of 2014 Act was emphasizing, I am not saying that. Maybe for further consultation, because rather than going for lock, stock, barrel, ending this procedure, we should have some reforms and go with this. Because we are already doing
reform NJAC or reform collegium?
Reform collegium. The memorandum of procedure has to be more transparent. And it should be why they are rejecting, like the case of Saurav Kripal we had. We don't know how and why he's not selected. And after that, we had that cases of other judges also in the past.
We know why he was not selected. And I'll tell you the reason.
Yeah, because of the partner was Swiss, which later we knew it after like so many years. So it should be on the, because then it gives the opportunity to the person who is aspiring to be a SC judge. Okay, I am like lagging behind in this area, I can improve upon. But if we don't give any option, any reason for his action, then the chance is
Should that be in public domain? Because that would be demoralizing for a candidate.
yeah, but right now there is one more thing that I wanted to say, because it should not be unfit to be judge of Supreme Court. At this point of time, he is not capable of being judge. So we leave that space that in future.
More or less the same.
No,
So we discussed Nirmal's case, but we did not select him because you're not fit for it.
no, not at this point of time. If he, in future he becomes better, we can take him back. That
Which
is,
means right now you are not,
yeah,
but you are a High Court judge.
yeah. Then it is
Then
Adam.
under, yes, okay. Yes, Abhay.
Yes, sir. So, in terms of NJAC, I'm good with having NJAC because of the transparency and accountability it brings in the appointment of judiciary. But the provision which you mentioned just now, which is it should be a unanimous decision, and if two or more judges disagree to it, or two or more members disagree to the like the name which is recommended, it may delay the appointments where the judiciary is already having a lot of vacancies. So that is one thing which may be reformed, and basically NJAC may require reform in that direction. And again, it may also, like, having NJAC will also go against the fundamental principle of independence of judiciary. So that is something I feel. Yeah.
Okay.
So maybe having NJAC is good, but again, with some reforms.
Vishek.
I'm against NJAC because there are
Now we
two
have the
things
real
that
Sharma ji ka beta in the class.
there are two things that comes to my mind. First is favoritism. Whenever those eminent person came into the picture, the favoritism can be from the leading party. The veto they can use, that can lead to
Which leading party?
the party, the eminent persons who are coming into the picture. They
Eminent
are
persons will
selected
be
from
from
the,
civil society. They won't be from a political party.
but they can tend towards the leading party.
How? Because look at the appointment authority. One is from judiciary. The other is from legislature. Do you think Rahul Gandhi and Modi ji will come together and suggest my name? Which means we will have genuinely credible people who will be part of this group, eminent persons.
Can't the credible persons be um, taken into the credit of favoritism from any of the parties, which can be the judicial
By that
power that
logic,
the
we can have no reform anywhere because every system will have some plus and minuses, some pros and cons. Let good not be the enemy of the perfect, or let perfect not be the enemy of good.
Right.
Maybe this is the best way. Maybe.
Maybe, sir.
Okay. Yes. Isha.
So I'm sorry, 1 second. Can you please? Okay, sorry. Sir, actually, I think that if we do have NJAC, it would sort of like the sanctity of the Supreme Court sort of diminishes the whole concept of Supreme Court, like it diminishes a little
So
bit.
did the concept of Supreme Court diminish from 1950 till 1993 when executive was the sole appointing authority?
So maybe that's why they came up with the collegium system. Because if, I don't know, like a lot of people look up to the justice system, maybe they need transparency more among them. And like you said, it doesn't have to be in public domain. It seems like awfully meddlesome for executive also to be in the process.
So members of the Constituent Assembly were fools that they gave executive the power.
So far, I don't think the collegium system has failed us to
It has
an
failed
extent.
us by vacancies, pendency of the cases, some of the incompetent judges who have been appointed as well.
So, but if we do have NJAC,
One
won't
judge
there be
who is,
problems?
who is now the chief, who is now the judge of the Supreme Court, Justice Pardiwala, when he was the judge of the Gujarat High Court, he said, one problem which is plaguing our system is reservation. Reservation should come to an end. But reservation is about social justice. So does this collegium system go through the philosophy of these judges and then recommend their names? What do they judge? Do they judge the number of judgments that they've given? It is common sense now, open secret, that judges don't write their own verdicts. Barring few exceptions, all these judges, they outsource their judgments.
So can I circle back to the idea of a democracy within the judiciary?
Then by that logic, I will tomorrow campaign for my post, appoint me a judge, and whenever a Muslim accused will appear before me, I will give him death sentence. I will be elected straight away.
So, but if the electoral role is all the judges in the whole country, would that still apply?
Maybe.
Yeah. So also my name is pronounced Esha. It's not.
Esha. Okay.
Thank you, sir.
Sorry.
Sir, I have one thing to add. Sir, NJAC is the
For that, you have to answer my questions.
Okay, sir.
Okay,
Sir, your
tell me.
questions. Sir, NJAC is the better idea, going with the collegium and all. Why? Because nowadays the transferring of judges is completely opaque. Yashwant Verma was transferred from Delhi High Court to Allahabad High Court.
It was not opaque because Allahabad High Court was the parent High Court of Justice Verma. That's why he was transferred there.
Sir, in case of Justice Muralidhar, who was hearing the Delhi riots case, he was transferred to Punjab High Court. Punjab. After that, he was transferred to Odisha and all. There was no logic.
Did government play a role there? That was collegium.
We don't know.
That was
Played the role.
collegium. Without the
that was
collegium's
opaque,
recommendations,
right?
the government would not have done that because government does not have the power. So blame the collegium.
Yeah, that's why I want the NJAC. There is no transparency there. Completely, it is opaque. We don't know what happening in the boardroom, in the collegium, what points they will discuss about, how we will transfer the judges. I think this is concerning part. And after that,
there are some things where we don't need transparency either. Do you want transparency in how we deal with nuclear secrets? Do you want transparency even at cabinet committee on security level? No. You can't have transparency everywhere.
Sir, but judges are directly impacting the society, right? Constitution, everything. They have more important role playing. Why?
I'm just being a devil's advocate. I'm not giving my opinion. I'm just proving it.
Nuclear, everything.
Maybe this is an area where there is no transparency required. Maybe.
Okay, sir.
Yes, Sanya.
So I am in favor of NJAC, and honestly, I would not be averse to the collegium system as well, because as Esha mentioned, that it has served us for very long. But also the thing is the lack of transparency and accountability. Along with that, somewhere I feel like the collegium system also favors male judges more, and there is less representation of female judges, something that's very required in India. And with NJAC, my only bone of contention is that the two eminent persons, they can be in favor of executive. And you mentioned that, Rahul Gandhi and Modi will not select the same person. But, as the saying goes, the pawns think they are enemies, but the ones playing chess are usually good friends. So I think in the NJAC, what we can do is primacy should be given to the judges so that the breaching of executive is not there. Otherwise, they will always appoint people who are pro-politicians.
Okay. When this NJAC was passed, the very next year, fourth judge's case was decided by the Supreme Court in 2015. And Supreme Court said NJAC is unconstitutional. And this judgment was given by a majority of 4:1. There was only one judge, Justice Chalameshwar, who said no, NJAC is not unconstitutional. But why did the Supreme Court say NJAC is unconstitutional? Supreme Court said, number one, it violates independence of judiciary. And particularly, the Supreme Court said, we don't want Home Minister to be part of it. And the fact that Home Minister is this Union Law and Justice Minister is part of it, the very fact that someone part of the executive is part of the NJAC, it violates independence of judiciary because executive and judiciary has to be separate from each other. So since it violates independence of judiciary, and second, it violates primacy of Chief Justice of India, which means primacy of judges in judicial appointments. This is also part of the basic structure of Indian Constitution. Both these are part of the basic structure. So whenever we have to criticize NJAC, we have to ensure and see whether NJAC violated independence of judiciary or not. Did NJAC violate independence of judiciary? Let's look at it. First, we need to understand what do we mean by independence of judiciary. One is the often discussed definition that judges should be not influenced by other organs of the state. So an independent judiciary should be insulated from executive, from judiciary, from legislature. That's what independence of judiciary is. But Justice Chandrachud says, independence of judiciary should also mean that I, as a judge, I should not be influenced by the trial by media. So if the Chief Judge of India, which is Arnab Goswami, proclaims 9 o'clock that this person is guilty, I should not get swayed by this. That is what we mean by independence of judiciary. I should look at the merits of this case and not be influenced by executive or legislature, not by media either. And I will have some inherent bias. I am a horrible person. Horrible. I am homophobic. I want LGBTQ community to be hanged. And I'm a judge. But when a case involving atrocities against transgenders or Dalits come to me, I hate Dalits. But when such a case comes to me, I have to let go of my bias and I have to discharge my duty according to the Constitution. That's independence of judiciary. So you are being influenced not by external entities, legislature or executive or media. You are influenced by your own bias. The very fact, the very way in which you can let go of your bias and stay independent from your own biasness as well. That's what independence of judiciary is. And did NJAC violate this independence? When Dr. Ambedkar was asked, what do you think is the most important office under the Constitution? He said the office of the CAG. Next, judges. Dr. Ambedkar was asked, then shouldn't, if judges are very important officers, shouldn't we give them independence? Dr. Ambedkar said 110%. Why not? Yes. How are you going to provide them independence? Through this. Judges of the High Court and Supreme Court, although appointed by the president, but they don't hold office during the pleasure of the president. They hold office till they attain a fixed age, 65 for a Supreme Court judge, 62 for a High Court judge. Unlike a governor, who is appointed by the president, but holds office during the pleasure of the president. And that is why this governor is towing the line of the ruling party, because if you don't do that, you will be transferred. If you don't do that, you'll be sacked. That does not happen with a judge. That's how we ensure independence. Salary, allowances, even pensions of the Supreme Court judges, High Court judges, charged on the Consolidated Fund of India. That's how we ensure independence. You cannot discuss the conduct of a judge in parliament, despite the fact that parliamentarians enjoy absolute freedom of speech. Absolute. But one thing that you can't do, discuss the conduct of judge, because that would violate independence of judiciary. That will put unnecessary pressure and burden on the judges. Don't do that. That's how we ensure independence. Dr. Ambedkar said these high courts and Supreme Court, they will have the power to punish people for contempt. And if at all these judges are to be removed, they have to be removed through such a complicated process that maybe the first judge in the history of independent India who will ever be removed will be Justice Verma in 2025. That's how we ensure independence. Now tell me, for God's sake, did NJAC snatch any of this? NJAC did not. Did NJAC say that from now onwards, judges will hold office during the pleasure of the president? Did NJAC say that now the salaries will have to be voted upon by the parliament? Did NJAC say that now we can discuss the conduct of judges inside legislature? Did NJAC say now Supreme Court does not have the power of contempt? Now, did NJAC say that NJAC will remove a judge? No. These features are still intact. The only thing which was checked, which was snatched, was the appointment process. Because that is how we keep a check on judiciary. And that is what the Constituent Assembly meant. Constituent Assembly said, yes, independence of judiciary is very important, but that does not mean you will have the final say in appointments and removal. That you will appoint yourself and you will remove yourself. No. It is through appointment and removal that we will keep a check on judiciary. We will appoint judges, executive, but then you will have independence. And if you violate the constitution, or if you are resorting to misbehavior, we will remove you. Parliament will have the power to pass a resolution and president will remove. As valued as judicial independence was to the assembly, the Constituent Assembly did not see the vesting of the ultimate power of appointing judges on the executive as an infraction of that principle. No. That does not mean if you empower executive with appointments, you are violating independence of judiciary. No. It saw, Constituent Assembly saw, this is very important for checks and balances. There are no reservations for SCs, STs, OBCs in the Supreme Court. And currently among the 33 judges, there is one SC judge, there is one OBC judge. The rest, Swarna class. Less than 25% of the judges in high courts belong to SCs, STs, OBCs, minorities. 13.5% of the women judges in higher judiciary. Who says this? Law Ministry data. Imagine now. This is original constitution. And this is the constitution after the enactment of NJAC. Original constitution gave judiciary only consultative role. The judges will be appointed by the president after consultation with the Chief Justice of India. Judges will be appointed by the president after consulting such of the judges of the Supreme Court and High Court as he may deem necessary. So the original constitution only gave consultative role. And was original constitution against the independence of judiciary? No. Then how can we even assume that NJAC, which does not give consultative role, gave deliberative role? Gave a sort of veto as well. Because if any name is not acceptable to Chief Justice and two senior judges, can such a name be appointed as the judge? No. So the final say, even with NJAC, was with the judges. Now imagine a scheme of the original constitution, which gives only consultative role to judiciary. That is not violation of the independence of judiciary. But a constitutional amendment which gives more power to judges is violation of independence of judiciary. This is unfathomable. Can't understand. But may his soul rest in peace. Ram Jethmalani. He was against collegium. He was against NJAC. Or Falias Nariman, against NJAC. Why? They said at least right now there is not much executive interference as it was previously. We will correct ourselves. We are a flourishing democracy. Yes, collegium has made mistakes. We will correct those mistakes. But we should not give this power to the executive. Then we will see the repeat of what happened in the 1970s. Some say recent reforms go a long way. And what are these recent reforms? Justice Sanjeev Khanna. You may call him the product of nepotism, but he was the one who had a very short yet very lively stint as the Chief Justice of India. He said, declare assets and put it on the website. Transparency means sunlight is the best disinfectant. We are appointed as the judges. Now we will reveal all our assets on our website, and High Court judges will do the same. That's transparency. As much as possible, the relatives of Supreme Court judges will not be appointed. To correct this perception that judiciary is full of nepotism. There are nepo kids in the judiciary. Third, we will reveal the criteria on the basis of which judges are recommended. Now, don't you think that is a welcome step in ensuring independence as well as transparency in the judiciary? As much as possible. Although this will go against good talent, because what if my father is a judge, but I'm also aspiring to be a better judicial person? Just because I was born in a family, that should not render me disqualified from being part of this judicial institution. I looked at my father and I want to also pursue it, for example. That should not be a crime. But this is a welcome step. Relatives of the Supreme Court judges, as much as possible, should not be appointed. We will reveal the criteria on the basis of which we are recommending names to the president, and we will declare assets on the website. Maybe that is the best way as of now. We don't need NJAC. But then the point is, even with collegium, executive has the last laugh. How? One fantastic lawyer, somebody I had the privilege of meeting multiple times, fantastic lawyer, Gopal Subramaniam. Who was Gopal Subramaniam? Who is Gopal Subramaniam? Fantastic Supreme Court judge, fantastic. I mean, no words, no adjectives that would justify. He was recommended by the Supreme Court Collegium to be appointed as the judge of the Supreme Court. Not a High Court judge, but he was the Supreme Court lawyer. He would have been a fantastic addition to the bench. President cannot take an independent decision. President is bound by the aid and advice of the Prime Minister, which means the central government did not want Gopal Subramaniam as the judge. Why? Because he was amicus curiae in the Gujarat riots case. Amicus curiae is the friend of the court. When a court is hearing a case, maybe they will appoint a senior lawyer to assist the court in giving justice, to come in helping to reach to a conclusion. The only mistake Gopal Subramaniam made was that he was the amicus curiae in the Gujarat riots case. When his name was recommended by the collegium, he was not appointed. And the problem was with the collegium. They did not reiterate his name. Ultimately, there was another mistake that Gopal Subramaniam committed. He publicly declared, I am backing out. Don't consider me, which he should not have. Let the matter be there. But you should not have backed out, because now the government has the option. Government has the excuse. You backed out, otherwise maybe we would have recruited you, appointed you. But maybe. One Delhi High Court lawyer, Saurabh Kirpal, his name was recommended by the collegium to be appointed as the Delhi High Court judge. Not appointed. Another lawyer of the Madras High Court was recommended, not appointed. Another lawyer of the Bombay High Court was recommended, not appointed. And we never got to know why, because all this is opaque. We don't know why. We don't know. No. Chief Justice Chandrachud, he did something fantastic. Because when the collegium will recommend names to the president and president wants to reconsider that name, you have to give it in written. What is your objection to this name? President is writing to the collegium that we don't want Saurabh Kirpal to be the judge of the Delhi High Court. Why? Because he is openly gay. And his partner is a Swiss national. Supreme Court collegium is writing back, reiterating the name, saying, so what? He is openly gay. Is homosexuality a crime? Read Navte Johar versus Union of India. Homosexuality is not a crime. And so what? His partner is a Swiss national. Is Switzerland an enemy country? By that logic, our external affairs minister has a Japanese partner. By that logic, prime minister has no partner. How does it matter? The name, what I'm trying to say is the name was recommended and reiterated again, yet not appointed. One advocate was recommended to the Madras High Court. His name was not acceptable to the government. Why? Because he had shared on his Twitter some news stories which were critical of the Prime Minister. And one judge was appointed, Miss Gauri. In no time, she was appointed. Collegium recommended her name, she was appointed. Because she was the office bearer of the BJP previously. And despite the fact that she had made communal remarks, some racist remarks in the past. But if somebody who is acceptable to executive is appointed without any delay, somebody not acceptable to executive is not appointed, which means then where is the independence of judiciary? Because even with collegium, executive has the last laugh, the final say. Then what do we need here? We need to finalize MOP. What is MOP? Memorandum of Procedure. Which means the collegium, together with the government, will have to make rules, and these rules will have to be followed in the appointment of the judges. Which means then these rules will clarify. Right now it's all opaque. These rules will clarify that when the recommendation comes from collegium to president, in how many days president will have to act. Then if you want to send the name back, in how many days? In how many days should the name be reiterated? These objections should be mentioned in the written format, whatever you agree. But please finalize this MOP as quickly as possible. Although we had MOP once, but now it needed to be updated. We don't have. Now the matter is before the court. What is this matter? Interesting matter. Very interesting matter. Justice Sanjay Krishan Kaul is the judge. And this judge bench is hearing a case. My lord, there is a delay. Delay? Collegium recommends name to the president. President is not appointing. In this process, what will happen? Because final say is with the collegium. Please act. Sanjay Krishan Kaul is giving time to the government. File your objections. File your arguments. Because if you don't do that, we will be constrained to take the law in our own hands. Which means what? Maybe tomorrow, Supreme Court will issue an order under Article 142 saying to give complete justice, this person is appointed as the judge of a Supreme Court without the approval of the President of India. That would be something strange, something devastating. But Sanjay Kishan Kaul says, we have no other choice. Please don't force us to take the law in our own hands. But then government delayed, and the time reached that Sanjay Kishan Kaul retired. Now there is a new bench which is hearing this case. Whether something of this sort will happen or not, we'll have to wait and watch. Wait and watch in the sense, what if the name which is recommended by the collegium not acceptable to the executive, or executive is delaying appointing that individual? In such circumstances, how will collegium behave? How will collegium respond? Can a judge of the Supreme Court be appointed without appointment by the president? Just like 10 bills were deemed to have been passed and signed by the governor and the president, even without the formal signature of the president and the governor. That would be interesting to watch. For that, let's wait and watch. This is how the judges are appointed. Any questions, please let me know.
Sir, even after fourth judge case, sir, this MOP judiciary having the broad shoulder, they invited executive to collaborate and do whatever is required to make it more transparent. So if executive is not coming forward, this thing like the SK call judgment, if it would have come, it would be regarding this only, like finalizing MOP.
Or maybe all, because see, who can be appointed as the Chief Justice of India? Senior most judge. So seniority is very important, which means when you are appointed to the Supreme Court, that also becomes important, right?
Yes. Yeah.
This collegium is sending 4 names. 2 names are not acted upon, 2 names are appointed.
Yes, seniority given.
Right? What will happen in this case? If they would have been appointed at the same time, their date of appointment would have been the same. They would have been the senior most. Then their age would determine. But if you cherry pick, you are affecting seniority.
Yes.
This matter is heard by the court. Whether you can cherry pick or not, we'll have to wait and watch for the final judgment.
Hello,
So-
sir.
Yes, Kaushal.
Sir, first of all, I want to say that I really feel an anxiety while speaking today. And sir, real doubt is that, sir, if ultimate power on appointment,
Why are you feeling anxious today?
sir, because
Remove the
of
mask. Remove the
Sir.
mask. Now smile.
Yes, sir.
Very good. Remove the mask fully.
Yes, sir.
Breathe in, breathe out. Very good. You're looking good today. Are you better?
Yes,
Very good.
sir, and I have a one doubt if ultimate power on appointing judge as CGI and a judge, then why Saurabh Kripal is not appointed as the High Court judge?
Because final order has to be issued by the president. President is not getting permission from the Prime Minister, which means even if the final authority is with the collegium, but then the final authority is the Prime Minister.
Sir, my second doubt is that if a NJAC, a Prime Minister opposition and a law minister and a justice decision concurrence on a CGI appointing judge of a court or minister.
Means?
Sir, in a NJAC and a PM opposition and a law minister, power decision concurrence on a CGI.
Decision will be through unanimity. That means all three people should agree that Kaushal is an eminent person. If they can't agree, then there will be voting, which means Modi ji as well as Rahul ji, in absence of Parli ji, will have to tell that yes, you are an eminent person.
Okay. But final decision will be with the CGI, right, sir?
No. Final will be majority of the three.
Okay.
In NJAC, finality will not be with CGI. Finality will be with majority. So decisions are to be taken by majority.
Okay. And I feel anxiety a bit because of my speech, sir. So that's why I'm sad today.
But you are speaking fluently.
Thank you, sir. But a low confidence was happened.
There is no confidence motion against you. You will survive as the member of the Platinum Batch.
So,
yes, Raj.
Sir, even if NJAC comes into existence, will it speed up the process of filling the vacancies?
No.
Because still the judges
hopefully yes, but by looking at the practice, no.
Because still
by that logic, collegium system should have resulted in much more swifter appointment. That hasn't happened.
Yes, sir. So what's the point in this particular NJAC, sir?
The point is, it will come in the exam. Critically analyze the Supreme Court verdict in 99th Constitutional Amendment Act 2015. This question was asked in 2015 mains. And can be asked in this year's mains as well. Yes, Rishabha.
So was the NJAC case, the 4 judges case, was taken suo motu by the Supreme Court or?
No. Supreme Court advocates on Records Association filed a petition before the court. Again, represented by Falias Nariman.
And if there will be a memorandum of procedure, then why is it required to have NJAC?
Because memorandum of procedure will only smoothen the to and fro between collegium and the executive. How the files will move. That's all. That will not solve the problem of opacity in collegium system. Collegium will still be present.
So that won't ensure the transparency which is required.
But now there is much more transparency. We will reveal whatever we discuss. Don't worry, we'll reveal it. Transparency is also because Justice Chandrachud said, this is what we received from the government, that they are objecting to Saurabh Kirpal and others because of these reasons. I want the country to know that these are the objections raised by the government. That's transparency. Yes, Esha.
Sir, do you think that maybe the hostility shown by the executive towards this whole topic is because the Supreme Court struck down NJAC so swiftly? Like, nobody's asking what's the process behind how the PM chooses his ministers. So, is it really such a big deal?
No, how Prime Minister chooses his ministers, ultimate accountability is with the public.
Yeah.
If the Prime Minister chooses ministers who are good for nothing, we will vote them out of power. But that's not the case with the judges. They're not accountable to anybody.
Yeah. Thank you,
Right?
sir. Yeah.
Thank you. So let's take a break now. Let's come back at 9:30 and we will discuss the remaining part of the feature film. See you on the other side of the break.
Hello, sir. That's Raj's side.
Yes, Chirag.
Sir, I just had a quick doubt. Sir, recently in a podcast, a journalist has spoken out that they don't want to be called Bodhi media. It is their constraint to be called Bodhi media and to toe the line of the government, to carry forward the propaganda of the government because they get advertisement from the government. If otherwise they will not be paid by the government to advertise government schemes. So don't you think that government should not be allowed to pay private news channel to advertise government schemes? Only government news channels like Doordarshan should be allowed to advertise
Who
government schemes.
watches Doordarshan?
But sir, then we will not be able to ensure independence of media now.
There are other ways of ensuring independence of media.
Sir, but
And
they
for
get
that, the
revenue from the
best
government side.
solution would be subscription-based model. You subscribe to these newspapers so that they are not dependent upon the government advertisement revenue. That's how you
Sir,
can
but
be
that is
totally independent. And there are
sir, but that
entities
is
which are
digital.
flourishing even without government advertisements. For example, News Laundry, Wire.
But sir, I am talking about the news channels which telecast on television.
For a long time, NDTV would not get the advertisements from the government.
Yes, sir. Now it is in the hand of government.
No, it is in the hands of Mr. Adani.
Sir, crony
Yes, until you
capitalism is
say
the
Adani is
reality of
government and
India.
government is Adani.
Sir, crony capitalism is the big issue in India, I think.
It is everywhere, not
Yeah,
just
sir,
in
it is
India.
everywhere.
It is everywhere.
But sir, I think Supreme Court should take a stand that the government should not be allowed to pay private news channels. Don't you think?
Why drag Supreme Court everywhere?
Sir, it is the
This
only
is where
savior right now in this
this is where the
democracy.
civil society activism will play a role. This is where
Okay.
individuals as pressure groups will play a role. But you can't drag Supreme Court everywhere.
Okay, but sir, yeah, I just thought ki then there will be no scope of independence now because they get revenue from the government side. So that's why I thought.
And that is true, but what is the alternative? Stop giving advertisements to newspapers, then how will you and me get to know about government schemes? How will we get to know about the advertisement, jobs? There used to be a separate newspaper, employment news. Who reads it?
Sir, hoardings, through
People have
hoardings
the
on
right to
streets.
know. That means the medium is through the newspapers as well.
Yes, sir. So through hoardings on the streets, it is an option. But I believe the news channels go at least they should not pay.
And they do put out hoardings on the streets.
Yes, sir.
You go to any filling station, you will see the hoardings of the Prime Minister.
Yes, sir. It is everywhere, sir, in Delhi.
Even on your COVID vaccine certificate.
Yes, sir.
Okay.
Thank you, sir.
Now, if judges are appointed for a term 65 years, if you are a Supreme Court judge, and 62 years if you're a High Court judge, and here maybe we can talk about one reform, and reform would be increasing the retirement age. For example, someone was referring to Justice Murlidhar, a fantastic judge of the Delhi High Court, then Punjab, then Odisha. He would have been an asset in the Supreme Court, but he was made to retire at the age of 62. He still had few years. Maybe we can equate, we can bring High Court judges at par with the Supreme Court and have the same retirement age as 65, or even enhance the retirement age to 70. Or to begin with 68, so that more and more judges are there, pendency of the cases can also be taken care of. That's one reform. But the point is, doctrine of checks and balances need to ensure that judges who are appointed, after their appointment, they continue to serve the Constitution, abide by the Constitution. That is why if you will not, and you will resort to something which is proved misbehavior or incapacity, then you can be removed as well, even before completing your tenure. So the judge of a Supreme Court as well as a High Court, because the appointment process and the removal process is now the same, the judge of the Supreme Court as well as the High Court can be removed. Who will remove the judge of the Supreme Court and High Court? The same entity who appoints you, which means the president. But president does not have a discretion here, unless and until both houses of the parliament pass a resolution by special majority. And what is that special majority? Majority of the total membership of the house and majority of 2/3 members present in voting. That means special majority flavor 2, which means this resolution will be a statutory resolution. So a judge of the Supreme Court and High Court can be removed even before their term ends by the order of the President of India, based on the statutory resolution passed by both houses of the Indian Parliament by special majority flavor 2. On what grounds? The grounds of proved misbehavior or incapacity. But what is this proved misbehavior or incapacity? This is not defined in the Constitution. The grounds are mentioned in the Constitution, but the real process is mentioned under the Judges Inquiry Act of 1968. What is misbehavior? For example, Justice Verma. Corruption. Half-burnt currency notes recovered from his house, which may amount to misbehavior. Misbehavior can be corruption as well. And on this ground, the judge can be removed. Or incapacity. Incapacity means what? I was appointed as a judge, but I had a sound mind. And later on, I turned insane. Now I will not be in a position to deliver justice. You may have sympathy with me, but you can't entrust me with the responsibility of imparting justice in the society. So on this ground of incapacity or proved misbehavior, I can be removed from my office. But here lies the problem as well. And the problem is, what about Justice Yadav? Anyone who knows about Justice Yadav?
Shekhar Yadav, sir.
Justice Shekhar Yadav of the Allahabad High Court. He had made communal remarks against Muslims that may amount to misbehavior and as such should be removed. But what is the process? How the judges can be removed? That process is clearly mentioned under the Judges Inquiry Act. And what is the process? You can either approach the Rajya Sabha or you can approach the Lok Sabha. If you approach the Lok Sabha, where is it mentioned? If you approach the Lok Sabha, 100 members have to give the signature. 100 MPs of Lok Sabha will have to sign this motion. If you approach the Rajya Sabha, 50 members of the Rajya Sabha will have to approach the chairperson. And then the matter will go to the Speaker of the Lok Sabha, if it is in Lok Sabha, or the chairman of the Rajya Sabha, if it is the Rajya Sabha. But they have the discretion. They can either admit this motion or reject. So a motion calling for the removal of the judge of the Supreme Court or High Court on the grounds of misbehavior and incapacity. This process can be initiated in either Lok Sabha or Rajya Sabha. If it is initiated in Rajya Sabha, 50 members of Rajya Sabha will have to write to the chairman. If it is initiated in Lok Sabha, 100 members of the Lok Sabha will have to write to the speaker. But then the speaker and the chairman will have the right to decide, discretion to decide whether to admit this motion or not. For example, when Justice Deepak Misra, he became the first sitting Chief Justice of India, against whom the motion was tried to be introduced by the Rajya Sabha because of some allegations which we have discussed in the past. But the chairman of the Rajya Sabha, Venkaiah Naidu, rejected this motion, saying, I will not admit this because this does not amount to misbehavior or incapacity. So the speaker, the presiding officer, will have the discretion. Now, if speaker or the chairman will accept this motion, then that house will have to constitute a committee, which means if Lok Sabha has accepted it, Lok Sabha speaker will set up a committee. If Rajya Sabha has accepted this, Rajya Sabha chairman will set up a committee. And who will be part of this committee? One will be the judge from a Supreme Court. One will be the Chief Justice of a High Court. One would be the eminent jurist. This committee will have to be set up. And then what this committee will do, will investigate. Investigate what? What are the charges against this judge? Do they amount to misbehavior or incapacity? And basis that report prepared by this committee, matter will go to the houses and they will have to vote. If both the houses pass a resolution by special majority flavor 2, I told you it becomes a statutory resolution and it becomes binding on the president to remove such a judge. But till date, no judge of the Supreme Court or High Court has ever been removed, although we have initiated processes. And what is the process? Process was against Punjab and Haryana High Court judge, was then the Chief Justice of Punjab and Haryana, then later on became the judge of the Supreme Court as well, Justice Veeraswamy. It was alleged that he misused the public money to renovate his private residence when he was the judge of the Punjab and Haryana High Court. Matter came to light. Motion was introduced in the Lok Sabha. A committee was set up. One eminent member of this committee was Falias Nariman. So this committee was set up and this committee recommended that yes, the charges are proven. You can go ahead, proceed with the removal of this judge. Lok Sabha passed the resolution, but Rajya Sabha did not because Congress party abstained from voting. And who was representing this judge in the parliament? Because this process in the parliament is basically a quasi-judicial process. Now, Parliament will investigate these charges and the judge will have the opportunity to defend himself. And before the Parliament, Kapil Sibal was the lawyer of Justice Veeraswamy. And how the circle turns. Who is representing Justice Yashwant Verma before the Supreme Court? Kapil Sibal. But be that as it may, when the motion got defeated in Rajya Sabha, Justice Ramaswamy survived. Then there was Justice Sumitra Sen of Calcutta High Court. But this time we had cross-party consensus that yes, we want to remove Justice Sumitra Sen. But before Parliament could initiate this process, Sumitra Sen resigned because he did not want to enter the history books as becoming the first judge to be removed from his office. So he resigned. Then just against Justice Pardiwala as well, against many other judges, against Chief Justice of India, Deepak Misra, and finally, Justice Yashwant Verma. But here lies the discretion of the speaker or the chairperson. So when the chairperson accepts the motion to remove Justice Yashwant Verma, there is already a motion pending to remove Justice Shekhar Yadav, but that has not been acted upon by the chairperson of the Rajya Sabha. Now comes an interesting question. What if 100 MPs of Lok Sabha and 50 MPs of Rajya Sabha? 100 MPs of Lok Sabha write to the speaker. 50 MPs of Rajya Sabha write to the chairperson. And now this happens at the same day. Who will set up that committee to investigate the allegations of misbehavior or incapacity against a judge? In this case, Judges Inquiry Act says both speaker as well as chairman, they will come together And together they will set up this 3-member committee. One, a judge of the Supreme Court, one Chief Justice of a High Court, one eminent jurist. And that is perhaps what led to the resignation of Mr. Dankar, the Vice President, because he accepted, allegedly, the motion moved by the opposition, which means now the spotlight will be on the opposition. Opposition-led movement, opposition-led motion will have to be discussed in the Rajya Sabha. And that is why it is argued that a parallel no-confidence motion was sought to be introduced by the government against Vice President, and maybe he could have been removed. He anticipated it, predicted it, and decided to resign instead. Or he was forced to resign, whatever that is. But then we were told that chairperson of Rajya Sabha had not admitted this motion. When he had not admitted this motion, that means the same day when 100 MPs of Lok Sabha wrote to the Speaker, Mr. Birla has accepted this motion. And now this committee will be constituted by the Speaker. And that committee will give its report, and that report will form the basis of the removal of the judge. And that is how the judge can be removed. This is about the removal of the judge of the Supreme Court or High Court. Now let's look at something else. Article 130, seat of the Supreme Court. The Supreme Court shall sit where? Right now it is in Delhi. But look at the wording, very important. Look at this carefully. The Supreme Court shall sit in Delhi or in such other place or places. That it means it may be possible that we can have different benches of the Supreme Court. We can have one bench in Delhi, another bench in Chennai, another bench in Calcutta, another bench in, let's say, Gandhinagar, wherever. We can have multiple benches. So the Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may, with the approval of the President, from time to time, appoint. This is where the argument lies. What is the argument? Justice delayed is justice denied. True? True. Justice hurried is justice buried. True. Justice should also be accessible. If it is not accessible, it is denial of justice. Sir, what are you trying to say? I'm saying, imagine, I am from Arunachal Pradesh. I lost a case in the district court. I filed an appeal before the High Court. The High Court is in Guwahati. I lost it. Where do I need to go now? I may file an appeal before the Supreme Court. But now I'm calculating costs. By calculating the costs, I realize I have to get the same lawyer who helped me in High Court and take him to Supreme Court. And in Supreme Court, I have to hire another lawyer who will file my case in the Supreme Court. Boarding, lodging, food, drinks, I'm calculating the costs. If I am from poor family, I will not afford this justice. What will I do? I will drop the idea of approaching the Supreme Court because this Supreme Court is inaccessible to me. A survey was conducted, and I will discuss that survey. Majority of the cases, more than 90% of the cases which reach the Supreme Court, they come from the neighboring high courts. Because from far away high courts, because of the distance, because of the time, because of the costs associated, you drop the idea of justice altogether. If I'm from Chennai, if I'm from deep south or deep northeast or deep west, Delhi dur ast. Delhi is very far for me. I cannot go to Delhi and file a case before the Supreme Court, which means majority of the people in this country, they will not be able to afford justice because the Supreme Court is in Delhi. Can't we think of a reform that we will have regional benches of the Supreme Court? Supreme Court can sit in Delhi and such other place and places as the Chief Justice of India, with the approval of the President, from time to time appoint. Maybe we can have one bench of the Supreme Court in Delhi, one we can have in Chennai, one we can have in Kolkata, maybe one we can have in Chandigarh or in Ambala, wherever. One maybe we can have in Gujarat, Surat, Ahmedabad, wherever. So we will then see that if the people from South India, because of the distance to Delhi, is dissuading them from approaching the Supreme Court, don't worry. You have a regional bench of the Supreme Court in Chennai, which will cater to the southern states of Tamil Nadu, Karnataka, Andhra, Telangana, maybe Odisha as well, maybe Kerala as well, maybe Puducherry as well. And if you are from Northeast and you are from Jharkhand or Bihar, maybe you can approach the regional bench of the Supreme Court in Calcutta. Maybe the northern states, Jammu and Kashmir, Himachal, Uttarakhand, they can approach Chandigarh, or they can approach Delhi. And people from West, they can approach the Supreme Court in Ahmedabad. That will make justice truly accessible to the public. And these regional benches should be constituted, because for that, you don't have to do any constitutional amendment. Because Constitution is clear under Article 30 that the Supreme Court can meet in Delhi or any other place or places as the Chief Justice with the approval of the President from time to time appoint. Union government is in favor. State governments are in favor. Bar Association is in favor. Parliamentary Committee on Law and Justice is in favor. But one entity which is opposed to this is Supreme Court is opposing it. Supreme Court is asked, dear Supreme Court, why? Why are you opposed to this idea? This idea. This sounds very promising idea. Supreme Court said, if we will constitute regional benches of the Supreme Court, it will affect the status of the Supreme Court as a national institution. Okay, sir. Any other argument that we have? Any other objection that you have? Yes. These regional benches may come under the influence of local politics. Now you tell me, is Supreme Court right in this argument?
No, sir.
Why?
Because if it is prone to come to the popular public opinion or politics, then Delhi is the most fertile ground because it is the epicenter of national politics. So second point is totally negated by this. And the first point is that it will affect the status of SC as an institution. We already have cassation benches of various high court circuit benches distributed like UP. In UP, we have Lucknow bench, Allahabad bench. So it does not affect the sanctity of the High Court. If High Court can have that, so can Supreme Court, and it will make justice more accessible.
First argument is it will affect the status of the Supreme Court as a national institution. Dear Supreme Court, very humbly, don't charge me for contempt. If you cannot cater to the population of the South, Northeast, Deep West, then you don't deserve to be called a national institution, because then you are catering to only those who are in the vicinity of Delhi. Then in any case, you are not a national institution. So this argument does not hold water. Second, if these regional benches can come under the influence of the local politics, then it would be better to abolish 24 high courts in all the states, because they can also come under the influence of the local politics. But we are not here to deal with rhetoric. We are here to deal with substance. And the substance is, whenever there is an allegation that a high court may come under the influence of the ruling political party in that state, we always have the option of transferring that case to a neighboring high court. When Gujarat riots were being investigated, matter reached the Gujarat High Court. Gujarat High Court was under the influence, or the allegation was that it is under the influence of the state government. The cases shifted, the trial shifted to Maharashtra. When there was an allegation that the case against J. Jayalalitha in the Madras High Court, in the disproportionate assets case, the court is coming under the influence of Jayalalitha, we transferred the case to Bengaluru, to Karnataka High Court. So we always have an option, but for God's sake, please implement this. Because only through regional benches can we cater to the massive population of this country, because we are geographically very vast. And the Supreme Court is not in a position to cater to the entire population of this country. But there is a bigger reform required. What is the reform required? Supreme Court, unfortunately, today is a bail court. Bail court in the sense, I have been denied bail in UAPA or in PMLA or in terrorism cases. I go to the Supreme Court because the High Court refuses a bail. For example, Ranveer Allahabadia had to approach the Supreme Court. The Professor Ali Khan Mahmoodabad had to approach the Supreme Court. Imran Pratap Gari had to approach the Supreme Court. So Supreme Court is now not a constitutional court, it's a bail court. Supreme Court hears cases such as marital disputes. Supreme Court hears cases involving appeals against the judgments of the rulings of the tribunals. So what, sir? Shouldn't Supreme Court hear these cases? No. Then what cases should the Supreme Court hear? Constitutional cases. The 9-judge constitution bench cases that we discussed in center-state relations, they were pending for more than 20 years. Electoral bonds case was pending for 5 years. Jammu and Kashmir reorganization case was pending for 5 years. Citizenship Amendment Act case is still pending, though the law was passed in 2019. So where is the time for the Supreme Court to look into constitutional cases? Should Belagavi or Belgaum be part of Maharashtra or Karnataka? This is a federal dispute involving 2 states. This case is pending in the Supreme Court since 2001. Not just pending. We still don't know whether the case would be admitted. So it is in pre-admission case. Because the Supreme Court does not have the time. Important constitutional matters take a lot of time for the Supreme Court to decide, because you are looking after these petty cases as well. Then, sir, what is the solution? Solution is something recommended by former Chief Justice of India, Justice K.G. Balakrishnan. K.G. Balakrishnan said, what we need is, we need to split Supreme Court. Just like for administrative convenience, we bifurcate, trifurcate states because a big state is difficult to be governed. It becomes an administrative nightmare to govern a big state. We need to split Supreme Court. Supreme Court into Constitutional Court, and Cassation Court. Constitutional Court can remain in Delhi. But what will this constitutional court decide? Here, it will hear only constitutional cases. Constitutional cases such as disputes involving Tamil Nadu governor and the state of Tamil Nadu, Punjab governor and the state of Punjab, Kerala governor and the state of Kerala, Kerala government and the central government. Because finance ministry has imposed limit to the amount of money that you can borrow. Kerala is saying we want to borrow more. Finance minister says no. There is a dispute whether the funds which are accrued to Tamil Nadu under various schemes, whether those money should be released or not, that matter is before the Supreme Court. Let the Supreme Court focus on these constitutional cases. Let the Supreme Court in Delhi focus on federal disputes. That's it, nothing else. Focus on this. Then what the cassation court will do? Cassation court can be like the court of appeal. Those cases which originate from the district court, move to the high court. You're not satisfied with the verdict of the high court. You move to the Supreme Court, but you can't move to the Supreme Court because the Supreme Court is in Delhi. You can go to a cassation court, and cassation court will have 4 benches: Northern, Eastern, Western, and Southern India. And it will hear only appeals against the judgments given by the high courts. Sir, when this looks very simple, then what is the problem? The problem is such a split of the Supreme Court involves constitutional amendment. Constitutional amendment, that too with flavor 3, which means ratification by the states as well. So what? If for NJAC, if we can get this flavor 3 special majority, why not for this? Which means we need political consensus. Not just political consensus, we need to consult the CJI as well. Because what if we do it tomorrow and Supreme Court tomorrow strikes it down and says this violates independence of judiciary, which is part of the basic structure of the Constitution. So the challenges to implementing the recommendations of Justice Balakrishnan is that it requires a constitutional amendment, that too with the ratification of the states, which is hard to get without political consensus. And you have to consult the judiciary as well. But this is a reform which we require. And as scholars would say, nobody can stop an idea whose time has come. Maybe it is the time for this idea to be implemented. But it is not as simple as that. Those who are in favor of constituting regional benches of the Supreme Court, what do they say? They say regional benches will make Supreme Court accessible and convenient to majority of the population. And this is something which was recommended by the National Commission for the Review of the Working of the Constitution, which was headed by Justice Venkat Salya. Set up regional benches so that it becomes easier for the people to approach these regional benches, which means the costs involved will come down. You're making justice easier, accessible to the people. And this will reduce backlog as well, which means if you create more regional benches, that means now the work would be spread, which means you will create infrastructure in these regional benches as well. You will appoint more judges as well. More judges means more pendency of the cases can be resolved. Very good. And it will reduce the burden in Delhi. Please implement this. That's the argument in favor. And it will also not only be affordable justice, it will be quick justice as well, speedier justice as well. And isn't a right to speedy trial also a fundamental right under Article 21? So in the interest of Article 21, please implement regional benches. And please understand, there is some local understanding, local context as well. Local context in the sense, if a high court in Kerala is hearing a particular matter involving social justice. The judges who are part of that society, because even if you are from outside of that state, but you're working in that state, you will become accustomed to some of the cultural things of that particular state. And you will understand the local culture much better, which means the local population much better. Maybe you will have that local context to decide a particular case. More regional benches means more localized understanding of the issues. Maybe these regional benches will be familiar with the regional languages. Although in High Court we use English as a language, but maybe there is somebody who is not able to speak English, and the judge can easily ask that individual to come and present his side of the story. Localized understanding because of more and more regional benches, very good. And this will decentralize the powers as well. Because judicial power is concentrated in Delhi. And if the powers are concentrated in Delhi, that's a feature of a unitary polity. If you really want a federal structure, a decentralized structure, you have to decentralize the judicial powers as well. And for that, we need regional benches. Something that I was talking to you about. Nick Robinson conducted a study in 2011, a legal scholar. And he said majority of the cases that reach the Supreme Court are from the high courts, which are closer to Delhi. Why? Because it is now affordable for us to reach to Delhi, to reach to the Supreme Court. Which means if more and more regional benches are constituted, we may eliminate this bias. But not everything is as simple as we made it out to be, because things can be complicated as well. And then there are stronger arguments against the establishment of regional benches of the Supreme Court. And the first is dilution of authority. It's like McDonald's, Aloo Tikki burger in Delhi or in Bengaluru or in a far-off village, if they have a McDonald's outlet, will taste the same. Unless and until you want to taste this McDonald's in Middle East or in US. There the taste will vary. But at least in India, it is of the same taste. It's like you are setting up franchisee model of judiciary. To set a franchisee model of judiciary, you should have same judicial jurisprudence to be applied, which may not be possible. That's the challenge. Logistical challenges as well. Because setting up regional benches would require significant resources in terms of infrastructure, manpower, money. New court buildings have to be set up. Then we have National Court Management System database, which tracks the pendency of the cases. That needs to be linked with these regional benches, although that's not a big challenge, but it's a challenge nevertheless. You might say we are no longer a poor country. We can afford, for the sake of the justice in this country, to spend more money on this infrastructure. But if we are spending more money on freebies, where can we leave money for this very important reform? That's another challenge. Not just dilution of authority, logistical challenges as well. Not just that, coordination and consistency issues. Multiple benches means maybe on the same issue, different judgments, different interpretations. Is right to marry a fundamental right or not? One regional bench will say yes, another regional bench will say no. In any case, this matter has to go to the Supreme Court in Delhi, which primarily means that it will be more chaotic. Because right now we move in a straight line, perpendicular, from district court to high court to Supreme Court in Delhi. Then we have to meander, first to district court, then to high court, then the regional bench, then all the way back to Delhi as well. Unless and until you say, no, this case will end at the regional bench. But what if one regional bench says right to marry is not a fundamental right? Another regional bench says right to marry is a fundamental right. There's a clash. What will apply in this country? And for God's sake, quality of judges. We can't have the same quality of judges in these different regional benches. Shetty Commission on Judicial Pay and Conditions highlighted this challenge, saying in ensuring the same quality of judges, or at least at par quality of judges, would be a challenge. That does not mean that just because of this, we should not consider this reform. But when the question is asked in the exam, you can mention this, that this is one big challenge. And there is bureaucracy in judiciary. Bureaucracy is not just in executive, it is also there in judiciary. There is a registrar. Without approaching the registrar, the case cannot be filed before the court. And sometimes Supreme Court judges are also worried, shocked, surprised. How did this case reach to us? Registrar, you are corrupt. How did this case appear before us when this case was filed much later and there are older cases which are pending? They have not been yet admitted. Maybe preferential treatment. Maybe these regional benches will come under the influence of the regional politicians or bureaucrats or businessmen, because it is easy to bribe locals as compared to bribing somebody at the center because you're not familiar to that individual. Areas Committee warned against the potential bureaucratic expansion that could accompany regional benches because that may be an incentive for corruption. But be that as it may, we have Article 130, which says the Supreme Court shall sit in Delhi or in any other place or places as the Chief Justice of India with the prior approval of the President from time to time appoint, which means if the question is asked, who can set up regional benches in the Supreme Court? Chief Justice with the approval of the President. Should there be regional benches? Strong arguments in favor. Should there be regional benches? Strong arguments against. Critically analyze the role played by the setting up of the regional benches of the Supreme Court. How far do you agree that setting up of the regional benches will solve the backlog of cases in Indian judicial system? So you'll have to mention arguments in favor, arguments against. Problem solved. Any questions, please let me know. And this can be the conclusion for your answer. And read this conclusion with me. The debate over setting up regional benches of the Supreme Court in India is multifaceted, with strong arguments on both sides. Various committees have provided valuable insights and recommendations that must be considered. While the regional benches could improve accessibility, reduce backlog, and ensure speedier justice, they also pose challenges related to consistency, logistical feasibility, and judicial authority. A decision in this regard must carefully weigh these pros and cons to ensure that the move ultimately strengthens Indian judicial system and upholds the principles of justice and fairness. Balanced conclusion. Both sides. Examiner will say, Wah, Modi ji Wah. Okay? Done. Questions, please.
Hello, sir.
How is your anxiety now, Kaushal?
Sir, my anxiety is well balanced, sir, now. Balanced.
Balanced. I'm hearing this term for the first time. Balanced anxiety.
Yes, sir. Yes. So, sir, my doubt is that, sir, in Article 124, what are the 7 judges and 33 judges? Sir,
In
and sir?
1950, when you were not born, Supreme Court had 1 Chief Justice and 7 judges. That was the composition. Can we increase the number of judges? We can. Currently, what is that number? 33 judges.
Okay.
Tomorrow, can we increase it further? To 53.
Yeah. Okay, sir. Thank you, sir.
Thank you. Dinesh.
Yes, sir. So I have a question. We see the instances where high courts serve some verdict, and
high courts
have served some verdict or their judgment in some cases, and the person appealed to Supreme Court, and the judgment will be something opposite to the judgment to the High Court.
Yes.
So in that scenario, is there any accountability or there is any cross questioning to High Courts that what was their interpretation on this?
No. You need to understand, although that is not the remit of these classes, but in Supreme Court will not revisit the evidence, will not start cross-examining the evidence or witnesses. That doesn't happen. Trial court gives a verdict, matter goes to the High Court. High Court will review whether the trial court has applied the law correctly or incorrectly, and basis that it will give the judgment. Supreme Court has only one role: to see whether the law was correctly applied or not, whether the jurisprudence was correctly applied or not, whether the evidence and the verdict relate to each other or not. It will not reopen the case. It will not rehear the case. It will not order the reinvestigation. It will strictly restrict itself to whether this is the evidence, and on the basis of this evidence, this could have been the judgment. It's about interpretation. High Court judges are not wrong. They only interpreted it differently. And Supreme Court is there to correct and apply it correctly. Sometimes it may be that Supreme Court is wrong, but High Court is right. When 7 High Court said habeas corpus cannot be suspended even during emergency, Supreme Court said no. So who is right here? High Courts, maybe in hindsight. But we say Supreme Court is right, not because it is always on the right side. We say it is right because it is final. Not because it is final, because it is right.
Means as a part of critical thinking, means as a person, I believe that justice is only one in any scenario.
No.
Okay.
There is your truth. There is my truth. So far as the only truth, the absolute truth is concerned, it doesn't exist. So let's say, who is right? Is Supreme Court right or the Union government right in prescribing time limit for the governors? Can you say there is only one justice in this case? Which is, yes, there should be a timeline for the governor.
Yeah, there should be a timeline for the governor.
But that's not mentioned in the Constitution.
But the person involved in these cases, while they are getting, or as a person seeing to these cases, we are witnessing that is in a single case, there are two type of judgments or two type of. So what is the
beyond that, critical for your critical thinking? It doesn't matter whether you go to the Supreme Court or High Court. What matters is who your lawyer is.
Sorry,
if you're able, who your lawyer is.
Okay, fine. Yes.
If you're able to get a sound, brilliant lawyer, even if you're a murderer, you will walk out scot-free.
Yeah, we have seen such instances.
Where? In movies? No.
No, yeah, in real life as well.
Tell me a real life example.
Like there was a, I was not remembering that case. There was a rape case that was took in a train. I was not remembering that person's name right now. One-handed accused he was.
In Chennai?
Yeah.
Okay.
I will recall myself. I'm not recalling any such cases.
So you got the idea now?
Yes. I'll think about it more.
Yes, great. Preeti?
Yes, sir. I have a doubt regarding the previous class. Sir, in Lakshmikant regarding the anti-defection law, in the criticism part, it says that it does not provide for expulsion of a legislator from his or her party for his or her activities outside the legislature. Sir, but
that's incorrect.
Incorrect, right? Okay. Okay. Yeah. Thank you.
Thank you. Rishiba?
So, won't the setting up of regional benches will increase the burden on public exchequer, and along with this, it
After
will
all, it
increase
is for the
vacancies as
public
well.
benefit. It is our money for our benefit. What's the harm? Should we
So
stop
there,
spending money for the welfare of the public?
no, we have to spend money for the welfare of the public, but no, we are not getting that much money at present that every person should receive the benefit. And we are focusing on setting up of regional benches, which will require more appointment of judges and more burden on exchequer.
So what? After all, it is for us. It's like I am earning and I can't spend this money on a luxury dining. I'm earning this money. No, but the government is saying, no, you can't spend this money. Why? I'm earning this after paying taxes. Then I have to pay another tax. But this is for my benefit. You and me pay tax. Imagine if you have to go to the court. Where are you from?
Rajasthan.
Rajasthan. You can go to Delhi. But Shiva is from Karnataka. His case is pending. For how long? 5 years. But he can't go to the Supreme Court. Just because he is from south of India. That doesn't, but he's also paying taxes. If his tax money will be used for setting up a regional bench, he can go to Bengaluru or Chennai. He can take a train, come back the same day.
So then there's another argument in that.
After all, then why do we not say, let's not have more schools because it will be burden on exchequer. Let's not have more airports because it will be a burden on the exchequer. Are you conjuice, miser, that you want to save your money? Spend it for the welfare of the public. So money should not be an argument.
Okay.
Yes, you can mention it that there will be financial cost. That is a concern. But that should not be the only concern, because just because we have to spend money, we will not do this. No.
Okay. So there's then another argument that we say that going to Supreme Court involves a lot of cost. So it is not for every person.
Yes.
If you will set up a regional bench, undoubtedly it will be a place nearby. Then it will save only the transportation cost. And what about the rest?
Food, lodging. Oyo is also costly now. Food, laundry, travel cost. Or even if you're poor, there is a free legal aid for you. But free legal aid is only you can choose from a panel of lawyers. Select one and he will represent you. But you still will have to go to the Supreme Court. You still will have to travel.
Okay.
So if that happens, you can get a lawyer from the panel. You are saving a lot of cost.
Got it. And the other is said that Supreme Court judges retire after age of 65 and High Court after 62. So
at 62.
At 62, sorry. These retired judges can be reappointed somewhere in a commission or any process.
What do you think?
So I don't have any idea.
All those who gave judgment in Ayodhya case rehabilitated.
As members of
That's
parliament
what,
or what?
You can be nominated to Rajya Sabha. Ranjan Gogoi was nominated. You can be appointed as the governor of Andhra. Justice Nazir was appointed. You can be appointed, for example, one judge, Justice Mishra, Arun Kumar Mishra. He said Prime Minister Modi is a born genius, versatile genius. When he speaks, the world listens. After his term got over, he became the chairperson of the National Human Rights Commission.
Okay. So
that's what Arun Jaitley said. Pre-retirement verdicts are dictated by post-retirement jobs. That is something that we will discuss in the reforms. The judges should be barred from holding any post-retirement. Okay. Yes, Asha.
So, in our answer, can we talk about the scope of technology or AI?
Yes, yes.
And
We will discuss that in reforms. We have not completed judiciary. We
okay.
have just completed parts: appointment, removal, regional benches. That's it.
Okay.
Tomorrow we will discuss what are the various powers of jurisdiction of the court: original, appellate, advisory, revisory. We'll discuss PIL, judicial activism, judicial overreach, judicial adventurism, judicial barbarism. All these terms we will discuss. Then we will discuss alternate dispute resolution. We'll discuss how exactly can we resolve the pendency of the cases. There we can specify the use of AI. Yes, it's a
Yeah.
beautiful, beautiful tool.
Thank you, sir.
Thank you. Lalit.
Hello, sir. This is not a subject-related doubt per se.
I understand. I am in touch with them. They I don't want to say that in front of
Yes,
everybody,
yes. Can
but
we
we
connect for
have
5 minutes, sir? Can we connect for 5 minutes later, if whenever you are free?
we'll connect tomorrow, because tomorrow I'll get the clarity.
Okay, sir. And you were saying something? Sorry, I interrupted. You were saying something.
No, because I did not want to say this in front of everybody, but I'll tell
Yes,
it privately. In
sure,
fact, I
sure.
think Abhishek sir would have mailed you. Did he?
No, sir, I didn't get an email.
Okay, I have asked him to send you a mail, but we will connect tomorrow, and tomorrow we will have the final confirmation.
Oh, okay, sir. You will mail me, or should I expect it from Abhishek, sir, or what?
No. I'll connect with you.
Okay, okay. So I'll be free all day. I'll be waiting for your mail whenever you're free.
100%.
Thank you
100%.
so much.
100%.
Thank you. Good night, sir.
Thank you.
Bye.
Good night. Rashmi.
Yes, my doubt was regarding the arguments against the regional benches. The very first point was dilution of authorities, right? So, sir, I'm not sure where you mentioned exact the same line, and I quote, jurisdiction must be same, but it is not. So, can you please like explain it? I didn't get at that instance.
For example, I gave you a right to marry, whether it is a fundamental right or not. There has to be consistency. When the Supreme Court says it is valid for the entire country, what if one regional bench says, let's say when it comes to the appeals against the tribunal awards, curative petitions have been used to overturn the award given by the tribunal. That can be done by Supreme Court. What if one regional bench decides that yes, we can do that, but the other regional bench says no? What is the law of the land? Because we say any verdict given by the Supreme Court under Article 141 becomes the law of the land. But whose law will be the law of the land? One, the regional bench, or the other regional bench? So that inconsistency we will have to take care of while establishing regional benches.
Got it, sir. That means there has to be unanimity, which won't be there, right? Not
Yes.
exactly.
Yes.
Thank you, sir.
Thank you. Jyoti.
Good evening, sir.
Good evening.
So I have a few doubts. So first is with respect to anti-defection law. So as the law says that there must be voluntary resignation, then only, and the other one is if the legislator violates the party whip. So, but there is no such mention that voluntary resignation has to be accompanied by joining some other political party.
No.
So, sir, if the legislator doesn't join other political party, then he
doesn't
won't.
matter. You can still be disqualified.
Okay.
What is the term used, phrase used? A member of a house belonging to a political party shall be disqualified if he or she voluntarily gives up the membership of the political party. Is it mentioned that, and then joining another political party? No. You voluntarily resign from your party, you're liable to be disqualified.
Okay. This means he can no longer be the MP. He won't be MP anymore.
No.
Sir, would it be automatic or the speaker has to?
No, speaker has to decide. There is no automatic disqualification.
So till then he would be joining as an independent member.
Till then, the matter is under dispute.
So he would be joining the House proceedings.
Yes, he can.
He can. And so, as the court declared that if the member is expelled by the political party, he can be independent member. So is it the president that has been set, or it has to be adjudged by
Case
the
to
court?
case basis. Case to case basis.
Okay,
Because
sir.
the law is unclear on this.
So my another doubt is, sir, is voluntary resignation doesn't include the formal resignation? It should be including a formal resignation as such.
It can be formal resignation where you are sending a letter of resignation. It can be that your conduct is such that we can assume that you have resigned.
Then, sir, in such a case, why the formal resignation prevented the disqualification and it led to reduction in total membership and the party saved from the coalition government?
Which party?
Like you told us, na Karnataka case where BJP was able to convince other legislator to resign formally in order to save disqualification.
They were not disqualified. They resigned.
That's what I'm saying, sir. Voluntary resignation includes...
Resignation from political party is one thing. Resignation from political party will make you disqualified. Resignation from house, from where are you disqualified? I myself saying I'm resigning from the house.
Okay, so they did not defected from the party, but they resigned from the house.
They defected, but first they resigned from Legislative Assembly so that they will not be disqualified. Now that we are not disqualified, we have only resigned. Now we have joined the BJP. Now BJP, make me a minister. Because you're
Sir,
not a defector.
That is why it is called the loophole of the law.
Yes, resignation is the new loophole.
Okay. So, what if an independent MP supports the party from outside and made
Even
minister?
if you support the government from inside by becoming a minister, you will not be disqualified because you are not joining a political party. You are as if you are part of a coalition government. And there is a coalition government with BJP, with JDU, with Chirag Paswan, with TDP. Does that mean TDP, Chirag Paswan and JDU will be disqualified? No, they're joining the government. They're not joining the BJP. If they join the BJP, they will be disqualified.
So, if an independent member supporting from outside made minister, chalega, matlab it would go.
100% dodega.
Okay. So, my other doubt is regulation made by governor with respect to fifth schedule areas. Is it subject to Article 246?
No, because it is under the domain of state legislature. You are not usurping the powers of the parliament and making rules for that scheduled area. No.
So this means he can make law on the union list subject as well.
No. How can he? No.
So that is why subject to Article 246 means he has to be limited in his domain.
110%. That goes without saying.
And if president wants to, or if any subject that has to be legislated upon that belongs to union list, the president has to intervene in such a case. Because no law applies to...
You're talking about Schedule 5 or Schedule 6?
Schedule 5.
Parliamentary law will be applicable to that area.
So
state legislative law will also be applicable. Schedule 5 area does not mean that state executive will not have any role in that area. State executive will exercise authority there as well. But there will be a Tribes Advisory Council which will advise the governor specifically with respect to land, transfer of land to non-tribals, money lending, economic matters. That's it.
And
on all other matters, state is present.
Okay, so this applies to 6th schedule, is it?
6th schedule means autonomy. The governor of Meghalaya, Assam, Mizoram, Tripura, they will decide whether state law will apply to these areas or not. President will decide whether parliamentary law will apply to these areas, except in Assam, governor will decide both with respect to state law as well as parliamentary law.
And sir, is governor bound by the advice in such a case?
No, you are running these areas in an independent discretionary manner. You're not bound by the advice of the council. Then you are violating the autonomy. It is as if then the state government is exercising authority over those tribal areas. That's exactly what we don't want. We want autonomy for them.
Autonomy. Sir, I have a few doubts. Can I continue? Like continue asking?
Have been continuing with
No,
doubts.
sir, because there might be other students as well. Okay,
No one else has raised their hand, so you can continue.
okay. So who is the final authority in fifth schedule area? Like governor when it comes
Governor.
to state list?
Governor.
Okay, okay, sir. So Article 358, which suspends the enforcement of Article 19 automatically when the national emergency is proclaimed on two bases. Sir, does it?
External aggression.
Yes, war and external aggression. Sir, does it suspends the Article 19 for the whole country, even if the national emergency is proclaimed for a particular region?
That president will decide whether it will be suspended in the entire country or in any part of the country or in any part of that state.
Because sir, Lakshmikant was mentioning that 19 will automatically suspend for the entire country. So that made
When
me
the emergency has not been imposed in the entire country, how will Article 19 be suspended for the entire country?
Yes, sir, that's what my question was. And so similarly for Article 359, that is
Yes.
to be done by presidential order only.
Yes.
So my other doubt is, so national emergency and so president rule can be extended beyond 1 year if both the conditions satisfied. National
Or
emergency.
one of the condition is satisfied.
Sir,
Either of
there
the,
is, sir, in constitution it is written and.
but it is either of the two conditions. It says and, but in case of Jammu and Kashmir, when president's rule was extended, it was done only on the ground that election commission has certified that we cannot conduct elections during this period.
Yes, sir, that's what my doubt was. So either of the condition.
Yes.
So there is so much confusion, Lakshmikant, regarding and or.
Discard Lakshmikant. Go through the bare act.
Okay, sir. So my last doubt. 1 second, sir. Yes, sir. So the parliament, in case of president rule, empowers the president for state legislative assemblies legislations. Parliament can empower the president, right?
Yes.
Sir,
Yes.
would it be
because role of the legislature will be taken over by parliament or any authority under the control of the parliament, which can be governor as well, president as well.
okay? So does it if the parliament assigns this power to president, this means the power is with now union government?
Power is in any case with union government.
There is no
That's what president's rule
discretion.
is.
There is no discretion.
That's what
here.
president's rule is. President's rule is centralization.
Okay. And sir, if president sanctions consolidate funds from consolidated fund of India to the state, would it be subject to parliamentary approval?
It is like a money bill. So yes, it will be subjected to the authority of the parliament. That's why in Manipur recently, budget was passed. That was passed by the parliament because parliament is acting as the legislature for Manipur.
Okay, sir. That's it, sir. Thank you so much.
Okay. Thank you, guys.
Sir,
Tomorrow.
Sir, I have a doubt. Like a small
Tomorrow,
doubt.
please, Gitanjali.
Yeah. Sure, sir.
Thank you. Bye-bye. Good night.